check, check. Hello, hello, hello. Hello, check, 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 check. Hello, hello.
না না না, তোমাকে দরকার আছে। আচ্ছা, তুমি তাহলে এসো এখানে, তুমি এখানে দাও।
সাউন্ড কি কন্ট্রোল করছো? এই তো
আমার কন্ট্রোল হয়ে গেছে।
হয়ে গেছে।
সাউন্ড ঠিক আছে, এবার ক্যামেরা কন্ট্রোল
টিউব লাইভ স্ট্রিম কি হচ্ছে? সাউন্ড চিন্তা করছে। তারপরে তুমি কি করে বাড়াবে? মানে এখন না, তখন বাড়াতে হবে। এক্ষুনি না।
যখন বললাম আমাকে একবার ইশারা করো।
আমি তো এখানেই দাঁড়াবো তাহলে।
না, হ্যাঁ, না।
Writing of the land is symbol of wisdom, knowledge, and enlightenment, so that we can begin our day with an auspicious start. I request you, Honorable
Professor Arnav Joshi, your scholarship enriches this house immensely. This conference calls upon us to revisit our indigenous frameworks of justice, rooted not just in law but in ethics, compassion, and responsibility, and of course, the larger moral fabric of the society. In an era of rapid global transformation, Indian knowledge systems remind us that justice is not merely punitive, it is restorative and deeply humanistic. This conference provides a space for such reflections, bridging ancient wisdom with contemporary legal realities. Academic activities, of course, can flourish only when the environment on campus is amicable and conducive. As the head of the institution, it is my responsibility to ensure that discipline is maintained and that all my staff work in a free environment where they can devote themselves fully to the betterment of our students and the institution. I am 100% committed to this. I wholeheartedly congratulate the faculty of departments of Sanskrit, political science, and education for their remarkable effort in securing the ICSSR grant to organize this seminar. My sincere thanks to all my teaching and non-teaching staff for extending their full-fledged support towards its successful organization. And of course, I request each one of you to contribute your little bit in maintaining this environment, academic environment, and encouraging diversity of thought while remaining within the purview of one's responsibilities. Only then can we move forward unhindered and take this institution to greater heights of glory. I urge other departments also to come forward and organize such seminars where meaningful exchange of knowledge can benefit society at large. On behalf of the entire Vidyasagar College for Women family, I once again extend a warm and respectful welcome to all dignitaries, scholars, researchers, and delegates. I am confident that the exchange of ideas today will inspire new pathways of thought and meaningful academic collaborations. Let us embark on this intellectual journey together with curiosity, humility, and a shared commitment to knowledge. Thank you, welcome, and namaskar.
Thank you, madam. Now I request Dr. T.L.E. বিশ্বাস, Assistant Professor of Department of Sanskrit and the convener of this international conference, to address this gathering.
Thank you, Rajiv sir. Let me begin with the Shanti mantra from Taittiriya Upanishad for peace and collective well-being. Om Sahana Bhavatu Sahano Bhunaktu Sahaviryam Kadavavahai Tejasvinavadhitamastu Ma Vidvishavahai Om Shanti Shanti Shanti. It is my great pleasure to welcome you all to this two-day international conference on ramifications of law and justice in the Indian knowledge system. As we began conceptualizing this event, we realized that law and justice stand at the very epicenter of any civilized society and in the Indian knowledge system. This relationship is beautifully woven into the profound fabric of dharma, a moral, ethical, and holistic framework that transcends mere legal codification. Today and tomorrow, we gather to explore how the wisdom of Vedas, the Smritis, and the Dharma Shastras continues to illuminate our understanding of governance, ethics, and justice. This international conference offers an important platform to revisit those timeless principles and reflects on their relevance in addressing contemporary legal and societal challenges. Holding this conference at Vidyasagar College for Women adds deep significance for Pandit Ishwar Chandra Vidyasagar, the great reformer after whom our college is named, exemplified the union of compassion and justice. His role in the Hindu Remarriage Act of 1856 was not merely legal reform, it was a restoration of dharma and human dignity.
May our deliberations today rekindle that eternal Indian vision of justice founded on truth, empathy, and righteousness. I'm delighted to share that we have received an overwhelming response. Around 200 participants have registered and 30 research papers from diverse disciplines have been submitted, reflecting the depth of interest in this field. Over the next 2 days, 19 distinguished resource persons from various fields, law, philosophy, Sanskrit, social sciences, and law, will deliver their insightful lectures. We look forward to listening to them, learning from them, and being enriched by their scholarship. The conference is structured into 6 thematic sessions, each designed to encourage dialogue, critical thinking, and interdisciplinary understanding. As an important academic outcome, we also plan to publish a peer-reviewed volume featuring selected papers and lectures from this conference, ensuring that the rich ideas shared here reach a wider scholarly audience. With this, I once again extend a warm welcome to all of you. Let us engage, reflect, and contribute together to a deeper and more meaningful understanding of law and justice within the Indian knowledge system. Let this conference be a meaningful dialogue, a bridge between our glorious past and the challenges of the present. I will now end my speech with a verse from the Mahanarayana Upanishad of the Krishna Yajurveda that beautifully express the essence of dharma. Loke dharmishtham praja upasarpanti dharmena papam apomudati dharme sarvam pratishthitam tasmad dharmam paramam vadati, which means dharma or the divine law constitutes the foundation of all affairs in the world. People respect one who adheres to dharma. Dharma destroys bad and sinful acts. Everything in this world is founded on dharma or law. Therefore, dharma is considered supreme and eternal. Thank you.
Now, it is my pleasure to invite Professor Bashok Choudhury to deliver his address. He is our chief guest. Before he starts, let me give a short introduction about Professor Choudhury. He is currently the principal of Heritage Institute of Technology, Kolkata, and Senior Director, Education at Kalyanbharti Trust. A chemical engineer by his profession, he did his BTech in Chemical Engineering from University of Calcutta. Then he did his Masters and PhD from Institute of Chemical Technology, Mumbai. Subsequently, he did his postdoc from University of Groningen, Netherlands, where he was offered the job of lecturer. But due to family reasons, he came back to Calcutta. He got a job of lecturer in the Department of Chemical Engineering under the University of Calcutta in 1990. He served the department as reader and professor. Subsequently, he became the registrar of the university and worked there for more than 7 years. Then he was appointed as the Vice Chancellor of West Bengal State University and served the university for more than 5.5 years. His tenure as Vice Chancellor ended in 2021. On February 22, 2021, at the end of his term as Vice Chancellor, he retired from the university service. Having 35 years of research, teaching, and industry collaboration, currently he is serving as the principal of Heritage Institute of Technology, a premier private university in Calcutta.
Good morning to all of you. Indeed, a very difficult task for me today that has been given by the respected principal and the team having Dr. P.L. Vishwas as one of the members to speak on Indian knowledge system in the context of law and justice and things like that, on which practically I have very, very less knowledge.
Yeah.
And when on the dais we have the respected principal, Professor Kutopadai, we have internationally well-known and a very famous scholar from the University of Texas at Austin, Professor Donald R. Davis. He is a professor and chair of the Department of Asian Studies over there. We have the IQAC chairperson or coordinator, Professor Topon Rai on the dais. We have the respected persons from different states of the country, from Madurai Kamraj University, from other universities, and the respected teachers from many colleges and universities of this particular state, of West Bengal or from other states, the students, researchers, ladies and gentlemen. And a very difficult task for me because, the Sanskrit is, first of all, not my subject, although I love Sanskrit and I can understand a little bit of Sanskrit. And when Madam told me it's become the chief guest, I did not know. I never thought that an internationally famous professor will be on the dais and I speak over there. But the point is, those who go to the very top, they have the kind of compassion and kindness. And when they find, little knowledge, it is a dangerous thing, but then, they somehow forgive it. So I know that, Professor David, Donald Davis will forgive me for the misconceptions that I may have and I may tell you. Yeah, and all of you are scholars of Dharma Shastra. Nowadays, after this NEP, National Education Policy 2020, what has really happened is that everyone is talking about Indian knowledge system. This is a very difficult thing. Very difficult thing because those who do not have that much of ideas of Indian knowledge system, they are also talking about Indian knowledge system, that India was a great society and this, that. I do not know whether they believe me whether India was a great society. But anything you look at, whenever you look at dharma or religion, you have to see what, in the binary opposition, what other ways. What other ways. You are losing your job for no reason. The kind of thing that happened to me once very late in my career. And that is adharma. But the point is, once you understand adharma, you can understand the adharma. Right? Adharma, you have to understand what adharma is. What sin is, Madam has told me just now. Madam has told all of you what adharma is, and from that point of view, you understand what adharma is. Something bad happening in the street of Kolkata, in the city. When you find that, and in the context of that, you try to understand what is happening, you try to feel that, this is good and this is right, yes, this is proper, this is improper in society, and as against that, there is something proper. So, from that point of view, when you see, that is basically dharma, that is basically justice. And it was Lord Buddha who very nicely understood this and said that an uncontrolled mind is the greatest enemy of human beings. An uncontrolled mind is the greatest enemy of human beings. Right? What is the uncontrolled mind? A lot of unnecessary thoughts are crowding in your mind, and that is basically Lord Buddha's. When Lord Buddha was asked, "What did you get out of this meditation?" He said, "I have not gained anything." What did you gain out of this meditation? Lord Buddha said, "I did not gain anything. I lost everything." What did he lose? Lost anger, he lost greed, he lost unnecessary idea of possessing certain things, he lost many other things that we are having a lot in our mind when we are talking about that. Right? So we have to understand. So I was in recent times, I was just studying, and you understand that the Krishna and Arjuna, when Arjuna, when they were talking about the Gita and the Gita came out, there he is talking about something, but little bit I know, very little I know. A little that is a very dangerous thing and one should not speak at all. And knowing fully well about that, I should tell you that when Arjuna said that, when Lord Krishna said that, Yogastha Guru Karmani, Shangam Takta Dhanurya, Siddho Siddha Samabhutta Samattam Yoga Uchyate. What is the meaning? Yogastha Guru Karmani. Whenever you do any work, you do it with a lot of mind. In it, Yogastha Guru Karmani, Sangam Takta Dhanurya, don't get attached to it. Siddho Siddha Samabhutta means success or failure, whatever comes, do not attach importance to it. Siddho Siddho Samabhutta, Samattam Yoga Uchyate. He's saying that again, in a different context, he's saying, Dukkeshu Anubhigdamana Sukeshu Vigatasliya, Vitaraga Bhayakrada, Sthito Dini Muri Vicya. He's saying that. So these are the different edicts through which our forefathers have given their knowledge and ideas about justice, about what should be the society. Now, when you talk about Manusmrita or when you talk about Chanakya Sutra, we find that they are extremely kind of difficult to digest in today's context, because when Manu says that the women and other things, when he's talking about, it was definitely not gender friendly. In today's world, you will never understand, you will never expect that kind of situation to exist over here. But when Manu said try to understand, all of Indian knowledge system, in my opinion, is about contextualization. The entire knowledge system that Indian people and Indian scholars did, you have to contextualize in that way. For example, when Aryabhata did, it is not Aryabhata, Aryabhata. He was not a Brahmin. When Aryabhata did, did the work on pi, 22/7. At that time, the Western scholars were also doing some study on pi. The Greeks were doing some study on pi. But at that point of time, the way Aryabhata had wanted, or Brahmagupta wanted mathematics to come, it was at that point of time new, and they saw the world in a totally different perspective. So that context is important. Are we seeing our science and technology today with the context that is totally different from, or rather totally akin to, similar to what is existing over there in Western countries? That point needs to be understood very properly. Our religion, when Manu did this Manu Samhita and things like that, at the time the tribal societies, they were tribal people. They were coming in the form of a society, and the rights of property was an important issue. And at that point of time, the women had a role to play, and he became, wanted women to keep together in the family. Family structure was not that, that well lit and things like that. And he tried to make some edicts, he tried to make some rules, and they were all on Manu Samhita. It all came like that. In today's context, that that law will not work. But you have to understand the society at that point of time. You have to understand the times at that time, and society times dictate what kind of justice system and justice you will get. Right. When Lord Krishna is saying, Arjuna, you do certain things accordingly and you follow your dharma. And your dharma is, to take part in the battle. This taking part in the battle is your dharma, and you do that. You do that for the righteous kind of thing. You do that to establish what is known as the correct thing over again. So that point, when he is saying, you have to contextualize that over there and understand. In today's context, whether it is correct or not, what is it is correct or not, you have to understand, you have to criticize with an eye of a scientist. That is basically important. I know certain things that I just thought that I tell you something, that why yesterday's law will not, law is something that is continuously changing, because the societal demand is continuously changing. So now I want to, I just prepared something and I will tell you something. Today I want to speak about something deeper than statutes, courtrooms, or procedures. I want to talk about the very foundation of law and justice, the foundation that lies not in the books but in the human mind. Ultimately, it is important, it is in the human mind. From the earliest days of civilization, societies have tried to create order out of chaos. Very, very important. Because we are from science background, we always talk about thermodynamics. And in thermodynamics, people talk about chaotic situation. Entropy. What is entropy? Entropy is basically chaos. Continuously, the entropy of the universe tends to the maximum, right? So chaos is continuously increasing, and whatever happens, thermodynamic law has been proved to be correct. So it is chaos. Monu, for instance, wrote laws not as eternal truths, but as instruments of social control meant to stabilize a turbulent world. Chanakya too created fiscal and administrative rules to ensure discipline in a kingdom where uncertainties were many and institutions were few. You have to understand that point of view. In today's context, it is not important. These ancient systems were not perfect. They were rigid, unequal, and often harsh. But they were attempts to bind society together when internal discipline was low and life was unpredictable. As centuries passed, philosophy stepped in, thinkers like Adi Shankaracharya reminded us that the world we see is not the ultimate reality. He said that Brahman alone is the Brahma, is alone is the true Brahma Shatya Jagat Mithya, you know, Sarvam Khalidam Brahma and all those stuff. And the apparent world is a kind of misconception. Western philosophers, thousands of miles away, wrestled with the same question. They debated what is real, what is imagined, and what the mind constructs. These explorations show us that reality is not always stable, and neither is society. And this is where modern law enters. This is the background. Now, today's laws are not carved on stone tables, those stone tablets. They are dynamic, constantly adapting to a society that changes every month, every year. Why does that change? Laws are changing, desires are changing, democracies are flourishing all over the world. And whatever, whether it is not, whether flourishing or not flourishing, at least the ideas in the mind of the people, they want to come out. Because modern society resembles something scientists call Brownian motion. What is Brownian motion? Brownian motion, when you see the light coming through the window, you will find the small particles moving in a very in different directions. You go to the street in Kolkata, just across in the Tontonia, you will find the autos going in the Brownian motions. And you want to control that. That is important. So, Brownian motion, particles moving randomly, colliding, bouncing, vibrating with energy. In the same way, human beings today are driven by countless impulses. What are the impulses? Ambition, fear, competition, desire, insecurity. These are the different things which are continuously creating systems, a turbulent system. Each person is a particle moving towards some goal, often undefined, and in that motion, collisions are inevitable. In physics, we call this chaos. In society, we call it conflict. And so, this purpose of law in our time is not to free society into obedience as Manu attempted, but to regulate the conditions, to reduce harm, to maintain order, and to ensure dignity in a world of accelerating motion. Things should develop, things should go faster. We should have lanes and bylanes where there will be bullet trains, there will be speedy vehicles, there will be air travels, and you want to be very, very fast in this system. And how can you keep people in or people or system in control? So laws will do that. Laws will not be tight, but or laws will be light at the same time tight. As Anil Shastro, the AICP chairman always says, law will be light and tight. Here is the core truth, therefore, and I believe this with conviction. The success of law does not depend only on the law book, it depends on the civilization of the mind. And the Indian philosophy has talked about this civilization of the mind. If you talk to Lord Buddha, he has talked about yoga Kuru Karmani. He has talked about that. Uddhamena hi siddhanti karyani no manoranjai. No, he sukta sasin. All these, you know much better than me because I am not a specialist scholar. point is, these are all important. Honesty becomes a very, very important thing. I mean, if your mind is does not want to do certain things which are not correct, there should not be any law. Law should be, the world is not ideal. It is a real world, and in order to keep that real world, in some form, we need law. In a society where minds are calm, compassionate, and ethical, laws rarely need to raise their voice. In a society where minds are heated, restless, or self-centered, even the best laws struggle to prevent confrontation. Right? Nothing wrong, nothing difficult. We saw this during the lockdowns across the world very recently. Some societies followed rules effortlessly because their internal discipline was strong. Others required enforcement at every step. This shows us a fundamental principle of human civilization. External law can regulate behavior, but only internal ethics can regulate conscience. Agree? That is what our ancient teachers from Buddha to Shankaracharya focused not on controlling society, but on shaping the individual consciousness. Buddha's Eightfold Path is not a legal code, it is a guide to reduce the chaos within. It teaches right thought, right actions, right speech, the principles that pull the mind and prevent unnecessary collisions. We often think law is what holds society together, but the truth is different. Law is only a framework. It is a human mind, disciplined, ethical, and aware that creates true justice. And the more civilized the mind, the less burden falls on the legal system. That is very, very important. So as we move to an age of rapid change, let us remember this simple but profound idea. A just society is built not only by good laws, but by sound minds. So what should be, as chief guest, without any knowledge of Dharma? Without any knowledge of Dharma, I should tell you something this that good laws are created within your mind. If you follow their dictum, if you follow certain discipline inside, the laws will allow you to work properly within what we have. But then the chaos that we see, we need to understand, we need to talk, we need to deliberate, and we need to, have this kind of seminar to really go into details and gradually come up with a more civilized society. With every day, civilization is gradually increasing in terms of, little bit, we call it delta X. So delta X. So that is happening. Thank you very much for giving me this opportunity. Let me tell you very frankly that without knowing much, I have said this, and I am a person who always but will agree that my knowledge in this particular subject is little because I am not from this discipline, but it was a pleasure to come to the Sheriff College and to do this duty. It is all goodness and kindness and compassion of all of you that you listen to me. Thank you, Phil.
Thank you, Professor Chaudhary, for your wonderful address. And we must acknowledge that, given your little knowledge, you have already set the tone of the conference. Now, I request Dr. Tapon Roy, the IUPAC convener of this college and senior faculty member of Department of Mathematics, to say a few words about this conference.
Morning, everyone. Respected principal madam, delegates from our various university and colleges, faculty members, participants, and honorable speakers from our country as well as from abroad. Professor Basab Chaudhary, he is a IPSC member, present IPSC member, and dear student. I am honored
to welcome you to this 2 days international conference on the ramification of law and justice in the Indian knowledge system. As the IPSC coordinator of Vidyasagar College for Women, I am proud to host this event that aims to explore the rich heritage of Indian knowledge and its relevance to contemporary law and justice. The Indian knowledge system has been a cornerstone of our civilization, shaping our values, culture, and institutions. The principle of dharma, justice, equality are deeply ingrained in our ancient text and tradition. This conference provides a platform for scholars, researchers, and practitioners to delve into these concepts and examine their application in modern times. This is going to open many more discussions, questions, which would provide enriching thoughts to the present time of our society. We will be discussing topics such as integrating Indian knowledge system into legal education, ancient judicial system, and role of Indian jurisprudence in shaping our laws. The conference will also feature esteemed speakers and panelists who will share their insights and expertise to this topic. I hope this conference will be a crystallized for meaningful discussion and collaboration, inspiring us to work towards a more just and equitable society. I express my thanks and gratitude to host departments for their relentless work to save this initiative of IQS. I hope the other department will organize conference and seminar in future. I am also grateful to ICSSR for their financial assistance towards this endeavor. I am truly eager to hear the esteemed speaker in the technical session. My best wishes, all of you present here. Thank you.
Thank you so much, sir. Now we have moved to the last segment of our inaugural session. This is the keynote address by Professor Donald Richard Davis. Yes, from all the ways in that space, he's a chair and professor at the Department of Asian Studies, University of Texas, Austin. Let me introduce him first and then hand it over to him, sir. Professor Davis did his PhD from the University of Texas and Austin in 2000 at the Asian Culture and Languages. He has published several books. To name a few on Hindu law and Dharmashastra, Hinduism. I mean, it's such an extensive publication that we will. I have not. I'm not speaking here, but what is interesting part is that he has entries in encyclopedia of philosophy of religion. That means entry in encyclopedia entry. Having an illustrious academic career and such an impressive publication record, his primary research concerns interaction of law and religion in medieval India. He works on the historical evidence of law and legal practice and inscriptions, textual archives, and other dated documents as a way to contextualize the law in earlier periods of Indian history. An erudite scholar, he takes deep interest in the practice of Hindu law in historical perspective, using materials beyond Dharmashastra texts and from many parts of the medieval India. It's a great honor to have you here, sir. Please join me in welcoming Professor Davis to deliver this inaugural keynote address. Thank you.
Good morning. I'm so very happy to be here at the conference. It's my first time in Kolkata, so I'm very pleased to have been invited to participate in this unique conference for me and I think for you as well. Before I begin with my presentation, I want to say a few words of thanks, first of all, to Professor Piali Biswas and the Sanskrit department at Vidyasagar College for Women for inviting me to participate in a conference that's really about Dharma Shastra and the intellectual history of India. And so I'm very honored to be here. I appreciate also all of the hospitality and great hosting that my new friend Radinda has given me and Principal Matt has shown me already. I look forward to many interactions with all of you during the conference. Now, where I would like to start is that when you get invited for a keynote address, there's a temptation to speak very big and to talk about generalities and so forth. And I'm going to do a little bit of that, but the group that I want to talk to is about 5 rows back and beyond. Because the generalities are important and they're good. But what we want to try to get to are the details. And so I want to speak to those of you in that and beyond the 5th row and say never be satisfied with the generalities. Always look for the details. Do the hard work that it takes to dig into the texts and the histories and the difficult work that makes academics scholarship really profound and rich. If you do that, you will find such beautiful, wonderful things in the history of India that you'll never be dissatisfied. I can testify to that. And so the big message today is that the Indian knowledge system and Dharma Shastra in particular, that has shaped me as a person and who I am for more than 30 years now. My whole career, my whole intellectual life is dependent on the Dharma Shastras and the richness that tradition has taught me about how to think about law and religion and history and so forth. That's the big picture. So I'm the testament in some ways to the beauty and profundity of the Indian knowledge system. But today, I want to talk to you about some details. Because I want to model for you what a kind of a depth is possible if you take the time. So today I'm going to present my recent research related to the concept of Swadharma in classical Sanskrit, especially in Dharma Shastra. And then I'm going to relate my conclusions about Swadharma to a bigger issue in the general study of law and jurisprudence. Conceptualizations of both Dharma and law have wrestled with the tension between general external rules and a personal internal sense of duty. And Principal was just speaking about this tension a moment ago. In the famous work, The Morality of Law, Lon Fuller sets forth 8 principles for what he calls the inner morality of law. These principles, in his view, enable the basic procedural moral foundation for any legal system, quite apart from any specific substantive provisions of the law. And the first of Fuller's principles is what he calls the requirement of generality. In short, generality means that you can't make a law for an individual. The law must apply generally to groups and to classes of people. There must be predictable patterns in judicial decisions so that legal cases and issues are not decided in an ad hoc or idiosyncratic manner. Law must be general. Though there are numerous concepts and institutions of classical Hindu law, through which to demonstrate its generality. Today, I'm going to focus on one, swadharma. Now, swadharma may at first not seem not to demonstrate that law must apply in a general way, not in a personal way. Whatever swadharma may mean today in contemporary India, in classical Sanskrit, swadharma means the rights and the duties proper to one's social position, especially caste and life stage, varna and ashrams. It does not mean in the classical tradition personal law, one's own law, individual nature, or something similar. It could mean those things, and in many modern discourses today, I think it has come to mean something close to that. But in the classical sources, it does not refer to a unique or personal set of individual moral obligations or commitments that are defined by a person's individuality. So in this talk, I'm going to try to substantiate this claim about the meaning of swadharma by examining the patterns in hundreds of instances of the word in several genres of Sanskrit, focusing on Dharma Shastra. I promise not to give you 100 examples, but yeah, I need to give you some substance though. The purpose of the talk, therefore, is to dislodge and discourage interpretations of swadharma in the classical sources as a personally determined and configured ethics, and to replace those with an idea of swadharma as something like caste law or group law or family law. And further, the specific problem I'm addressing is that we should not project a modern meaning of swadharma back onto the classical meaning without making a distinction between the two. This mistake, I think, is found both among academics and among many practicing Hindu theologians and teachers. Now, the compound word swadharma occurs frequently and especially in mainstream Hindu texts. If we break the compound down, swa is a reflexive adjective referring back to a subject, the English own or oneself. Dharma, of course, is a famously multifaceted word with meanings ranging from law, ethics, righteousness, religion, but also to justice, right, and good, depending on the context. Putting the two words together, a reasonable, but in my opinion, erroneous translation would be one's own law or morality. A rendering that suggests the moral obligations of each individual. Based on the evidence that follows, however, I will try to show that swadharma instead means something like the law or morality that's proper or appropriate to one's own position in society. Swa here means proper or appropriate in these contexts. Proper or appropriate to what is the question. The proper or appropriate source of law or morality in swadharma is a group, not an individual. Furthermore, the most common group in question is a social class, a varna, a caste, a jati, or an idealized stage of life, an ashrama. Less frequently, it refers to duties and rights that emerge from membership in another social group, such as a guild, a monastic order, a military unit, a professional class, or a family. In every case, however, the dharma in question belongs to a socially defined group and to the set of norms recognized by that group. Swadharma, therefore, refers to an external morality imposed by a group, not to an internal sense of personal duty, responsibility, or ability. Stated bluntly, swadharma almost always means varnashrama dharma in classical Sanskrit, or the duties that are prescribed for some other class of people, another group of people. So let's take a look first at some examples from the earliest texts of the Dharma Shastra and Arthashastra traditions. In these texts, we will see patterns in the use and meaning of swadharma that will persist in many other genres. Perhaps the most famous shloka about swadharma occurs in both the Madhava Dharma Shastra and the Bhagavad Gita, slight variations. In Madhava Dharma Shastra 1097, the text reads, Param swadharmo viguno na parakya swanishukita paradharmena jivanhi sadhya pattati jatita. In English, something like this. Better to follow the law of one's own class poorly than that of another class well. for one who lives by the law of another class immediately falls from caste. Now, this verse is very close in form and content to two verses in the Gita, which I'm sure are well known to you, 335 and 1847. But I'm going to save those for the conclusion because they have become the classic points of reference in modern discussions around Swadharma. Turning back to Manu's verse, however, this verse occurs at the end of chapter 10, which covers the dangers of mixed class unions, Varna Sangha, and the law for times of distress and emergency, Apatdharma. The preceding verse, the one before this one, commands the king to punish those who take up work belonging to a higher class, and the verse that comes after authorizes Vaishyas who cannot live by following the law of their own class to take up the livelihood of Shudras. The rule that livelihoods taken up in a time of emergency must be anuloma, in the natural order of social class, recurs as one of the main contexts in which the category of Swadharma is used. In short, the thematic context concerns the social classes, the Varnas, and the work or livelihood that's appropriate to each class. The use of Swadharma here, therefore, refers to the norms connected to a particular social class. Consider next how many instances of Swadharma we see in legal contexts. These instances are important because laws are not made for or pegged to individuals. Laws have to govern groups or categories of people following this requirement of generality that Fuller described. Here, the idea of Swadharma as a rule unique to an individual doesn't really make sense, as we can see in the many instances where kings are commanded to protect the integrity and boundaries of the classes and life stages among their subjects. Here are a few examples. In the Gautama Dharma Sutra, we read, the king should watch over the social classes and the orders of life in conformity with their rules, and those who stray, he should guide back to their respective duties, their Swadharma. The Gautama Dharma Sutra 1129 then says, people belonging to different classes and orders of life who are steadfastly devoted to the laws proper to them, Swaswadharma Nishta, they enjoy the fruits of their deeds after death. And then, with the residue of those fruits, they take birth again in a prosperous region, a high caste, a distinguished family, with a handsome body, long life, deep Vedic learning, and virtuous conduct, and with great wealth, happiness, and intelligence. Then we can look at the Arthashastra, the Kautilya Arthashastra, 1:3:14-16. Swadharma, he says, leads to heaven and to the infinite. When it is violated, people are destroyed through the intermixture of class and order of life. Therefore, the king should not permit people to violate Swadharma, for when they adhere to it, they rejoice here and in the hereafter. Finally, then, the Manava Dharma Shastra says the king, who knows the law, who knows Dharma, should examine the laws of the castes, regions, guilds, and families, and only then settle the law specific to each group, the Swadharma. Even men living far away endear themselves to the world when they perform their proper activities, Swami Karmani, and remain firm in their proper activities, Sve Karmani. In the last example from Manu, the reference for Swa must be the groups named in the first part of the rule. Individuals do not figure in an examination of the laws current in various groups. The point of the rule is that the king must respect and enforce the respective laws of the major social groups in his realm. The range of such groups is broader than just Varna, but the Swa in Swadharma here refer to customs and major communities. Each caste, region, guild, and family has settled norms and activities that define them as a group. Furthermore, one must comport oneself according to one's social station, even when not at home. Respect, the text tells us, emerges from such moral consistency. The other cited passages above emphasize the social and spiritual benefits that come when a king ensures that each Varna in the ashrama follows the duties prescribed for them. The king bears a heavy burden to uphold this compliance, and later texts repeat this rule and this burden. In fact, keeping, even forcing subjects to observe the dharmas of their social class is a common legal context in which swadharma occurs. I would go so far as to say that it is the essence of the king's duty to protect his people in this way. For instance, in the Agnivalkya Smriti 1:358, we read, "No one who strays from the law proper to them should go unpunished by the king. Not a brother, not a son, a person of respect, a father-in-law, or a maternal uncle." Or what about this passage from the Ramayana? The Kshatriyas accepted the Brahmins as their superiors, and the Vaishyas were subservient to the Kshatriyas. The Shudras, devoted to their proper duty, their swadharma, served the other three classes. In short, the city was well governed by that lord of the Ikshvakus, as it had been long ago by the wise Manu, foremost among men. Social order here means class hierarchy. We see the same requirement that kings enforce Varna Dharma in Purana texts, such as the Markandeya Purana. The Markandeya reads like this: "Some fools take up the wrong path and deviate from the law of their social class. The king who keeps them in their own law attains heaven. If the laws of the social classes and stages of life do not weaken in a kingdom, then, dear one, its king will ever have joy in the next world and in this. The highest duty of a king, and the thing that produces his achievements, is to ensure that men accept their social class, those ignorant ones who have fallen away." Now, these examples like this could easily be multiplied, but I think the point is clear. Swadharma in legal contexts refers to the social order promulgated under the Chaturvarnya ideal. Each individual's dharma is prescribed as their own, because they belong to one class or another. The swadharmas required of individuals within a specific varna or other social group are the same. They are general in fuller sense, applying equally to all the members of a particular group. So the generality of swadharma as applying to groups is important because it precludes any interpretation of swa as personal or applying only to oneself. Instead, we have to think of swa as meaning appropriate to oneself, in the sense that of what is expected of a person is what is expected of anybody who belongs to a particular social group. The philosopher Rajendra Prasad, not the president, the philosopher Rajendra Prasad pointed out not long ago. He writes, "Swadharma really means swavarna dharma, the dharma or set of obligations which any individual belonging to any varna ought to fulfill by virtue of his belonging to that varna. That is, that which he ought to fulfill as a member of that varna." So, following Prasad, I would contend that the swa in swadharma refers to an implied but unstated middle element, such as swavarna dharma, swashrama dharma, swashreni dharma, swakula dharma, swadesha dharma, and so on. The relevant group is made clear by context. In this sense, Rajendra Prasad seems to understand swadharma as what I think grammarians would call a madhyama pada lopi samasa, a compound in which the middle term is dropped. In principle, every instance of swadharma should imply an unstated middle term which defines the group within which the dharma should be included. So let me turn now to a couple of examples outside the direct domain of law. For the beginning of the 7th chapter of Manu, we read this: "It is the fear of the king that makes all beings, both mobile and immobile, accede to being used and not deviate from the law proper to them." Now, the commentaries on Manu take this figurative metaphor very seriously, and they talk about immobile trees and plants that do not flower out of season for fear of being cut down. How much more, they say, would mobile beings not deviate from their proper duties? For the commentator Govindaraja, for example, the metaphor emphasizes that groups of stavara beings, that is, trees and plants, are the model for groups of jangama beings. Though this passage occurs within the Rajadharma section of Manu, it is telling that the point of comparison in this metaphor comes from nature and the idea that each species has its proper duties. The parallel in the human world is, of course, caste, but also myriad other social groups to which we all belong. Now, the Ramayana contains, by my count, 13 instances of Swadharma. Many repeat the idea that each Varna has its unique duties. I mentioned one above. But others point to the special duties that are appropriate to other groups. When Ram decides to accept his exile in the forest, as you all know, Sita declares that she too will accompany him. Now, warning her of the dangers and tribulations of the forest, Ram initially insists that she must remain in Ayodhya. He says, "My dear Sita, you are from a great family and you are ever devoted to righteousness. Here, you shall perform your proper duty, not what pleases your heart." That proper duty is Swadharma. Now, this verse highlights the contrast between doing what feels right and following what is socially expected. Even though Sita eventually accompanies Rama to exile in the forest, at this point, Ram is trying to remind her of her position as a wife who should obey her husband. That obedience is her Swadharma, her duty as a wife and as a woman, as opposed to her personal conviction to go with Ram. In the end, Sita's argument prevails that her Stri Swadharma, to stay with and support Rama, actually outweighs her duty to obey his command. But for my purposes today, the whole episode reinforces the idea that women too have dharmas as women, as a group. In the Ramayana too, even demons have a special set of duties. Or here perhaps moral traits that distinguish them from other social groups. Ravana himself tells Sita, he says, "Frightened woman, there is no doubt at all that having sex with other men's wives and carrying them off by force falls into the proper duties of demons." Here is a propensity to sexual transgression and the special law of Rakshasa marriage. This is portrayed as a natural trait of the demons as a group. It is hardly typical of just Ravana. Though Ravana refrains from carrying out the threat that is implicit in his statement, his matter-of-fact summary of the Swadharma of demons attributes specific propensities and even obligations to that group, to the Rakshasas. One final example I'll give you from Dundan's Dashakumara Charita. In the story of the courtesan, Kama Manjari, her mother explains to the forest sage Marichi, from whom Kama Manjari sought refuge, that she has been following her obligations as the mother of a courtesan by training her daughter in the ways of the courtesan class and, quote, causing her to take up the rights and duties of her class. Swadhikara Anushtavan. The text describes in detail the training, comportment, and the client management required of a courtesan and her mother. Later, the mother states that her daughter has violated her proper duties as ordained by the god Prajapati. Anaya Prajapati Vihitam Swadharmam Ullamya. Marichi tells Kama Manjari to heed her mother and attain heaven, which is easy to reach by following the duties of one's family. Sulava Kula Dharma Anushtainaha. In the course of this tale, we encounter references to Ganika Swadharma and Swakula Dharma. In these compounds, the lost element is stated, affirming Prasad's intuition that a word for the relevant group is implied in most usages of Swadharma. In this case, the Swadharmas of the courtesan class, the Ganikas, are described in great detail. Now, I will wrap up my evidence with a brief consideration of the most famous instances of Swadharma from the Bhagavad Gita. This is 335 and 1847. Better to follow the law of one's own social class badly than that of another well. Better to die in the law of one's own class. The duty of another class brings danger, right? Shreyan Swadharmo Viguna, Paradharma Svanushtita, Swadharme Nidanam Shreya, Paradharmo Bayava. And then 1847, right? Shreyan Swadharmo Viguna, Paradharma Svanushtita. Swabhavaniyatam Karma Purvan Napnoti Kilvisham. This one means something like better to follow the laws of your own class badly than that of another well. Performing actions restricted to one's own social position, one does not incur sin. Though the Gita has inspired interpretations of great variety, one basic element of the encounter between Arjuna and Krishna is the call for Arjuna to accept his duty as a warrior and engage in the battle at the heart of the Mahabharata. First and foremost, these verses emphasize Arjuna's obligation to fight because he belongs to the Kshatriya class. Over and over, the commentators on the Gita equate Swadharma with Varnashrama Dharma. On 335, Madhusudana glosses Swadharma as, quote, that which is prescribed for each class and life stage. Swadharmo yam varnashramam pa prati yogihita. Baladeva on the same verse says, the law prescribed by the Veda for each class and life stage, even if it is defective or missing some elements, is better than the law of another, even well performed, carried out with all the required elements together. For example, he says, the Swadharma of the Brahman is non-violence, and so on. And for the Kshatriya, it is war, and so on. For the law is not understood by any other source than the Veda. That's full quote. Swadharma here has nothing to do with a calling or a personal talent. It is defined by the Vedic tradition and by the class to which one belongs. Other commentators such as Vishwanatha, Sridhara, Anandatirtha regularly gloss Swadharma in these verses and elsewhere as Yuddha Adhika, highlighting Arjuna's class duty. The opposite is Diksharanadi Rupa Paradharma, the law of another that takes the form of begging and so on. Shankara, for instance, and interestingly, does not comment extensively on either of these verses, except to employ a regular metaphor that suggests that there are no bad effects of violence on a Kshatriya. On 1847 in the Gita, he states, just as poison causes no harm to the insect born in that poison, so also a person who acts in conformity with his class status does not commit a sin or a transgression. Now, Ramanuja, on the other hand, acknowledges first that the acts in accordance with Varnashrama Dharma follow the constituent attributes, the gunas, of one's social station, and thus are the essence of, in his view, karma yoga, disciplined activity in the world. His conclusion regarding Gita 1847, however, takes the novel position that Swadharma refers to karma yoga, that is, to all the differentiated duties of the social classes, while Paradharma refers to jnana yoga, the very difficult to practice discipline that often causes one to neglect obligatory actions. Very interesting shift. Performing one's caste duties with the right attitude, therefore, is better than risking the pitfalls of taking up the renunciatory path of knowledge prematurely. In this way, Ramanuja still understands Swadharma to refer to, quote, acts proper to one's station and stage of life, but he lumps all of these together under the Gita's notion of karma yoga. Paradharma, then, in turn, is the dharma that is the other type of person, namely one pursuing the path of knowledge. But this path, according to Ramanuja, is fraught and ill-advised until and unless the individual has fulfilled all the actions with detachment and knowledge that they understand that they are not the true agent of the actions. The Varna groups discussed in detail just before 1847 provide a context for Ramanuja's articulation of karma yoga. He takes the fourfold Varna system for granted as the natural order of society, driven by different preponderances of the gunas in the four social groups or social classes. Now, at this point, and I'm starting to wrap up, I may seem very far from law and jurisprudence, but let me see if I can convince you that I'm not. The case of Swadharma demonstrates at least two important facts about legal thought in Sanskrit. First, as I've emphasized throughout, Swadharma focuses on group identities and duties, a point which I hope the evidence I gave has shown. Hindu jurists understood that law must be general. It must apply in the form of rules that prescribe the duties and restraints of specific groups. One critical task for any legal system is to categorize people to whom a law applies. The law can only recognize legal identities And part of the task of the Dharma Shastra was to convert social groupings and identities into legal identities, to state which ritual and legal obligations apply to which social groups. In this respect, classical Hindu law parallels other legal traditions by creating rules that meet the generality requirement in Fuller's sense. Now, remember that this requirement is one of 8 requirements that Fuller describes, including things like the promulgation of the law, clarity, non-contradiction, non-retrospective law, and consistency. Classical Hindu law fulfills all of these expectations and thus provides a solid moral foundation for the legal system. Even the final and most difficult requirement, which is congruence between official action and declared law, is met in Dharma Shastra. The standard of Dharma in this tradition is the Shishta, the educated and virtuous person. An immoral, undisciplined person, no matter how powerful, can never say what the law is or judge it for others. Dharma binds all people, and any official act must be judged according to the rules of the Shastra and of those who abide by it. This is simply the rule of law as implemented by the lawful. The rule of law and the rule of the lawful. Our examination of Swadharma offers a second insight of jurisprudence. Classical Hindu law thinks in groups. When I said above that the law must be general, I did not say that it must be universal. It's the same for all individuals. Indeed, one of the distinctive features of Sanskrit jurisprudence is its commitment to intermediate social groups. Laws that apply to everyone, the sadharana dharmas, which many of you probably know, are very abstract and also very few, and they require, in every case, further specification. Right? They're things like forbearance and truth and very abstract principles. The Hindu law tradition actually does very little with these universal laws. Instead, the laws are made for identifiable social groups, and those groups are also recognized as having the capacity to make valid laws for themselves, which or something. And such intermediate laws existed in abundance for merchants, for trade deals, military groups, monastic communities, caste families, and localities. Ideally, laws in force were suited in scale, content to the communities governed by them. So this is the point about context that Sarah was mentioning earlier. Dharma Shastra authors would have thought it preposterous to define just one set of rules for all people, irrespective of their identities, status, social position, and so on. That's not how Dharma works. It lives in the middle. Dharma applies neither to the individual alone, nor to the society as a whole. Swadharma emphasizes the value of this intermediate terrain as the best frame within which law can function. Our human experience consists largely of moving between familiar social groups, family, business, religious community, friends, classmates, neighborhoods, and so on. Why shouldn't the law mostly focus on this scale or level of human experience? To conclude, then, I hope this short inquiry into the meaning of Swadharma in classical Sanskrit has helped to clarify its conceptual place in the history of Hindu law, and from there into wider circles of Sanskrit literature. Each time I look into the semantic history of Sanskrit legal vocabulary, I always find ideas both familiar and new. I look forward to hearing about the research of the scholars assembled for the conference and to learning from all of you about both familiar and new aspects of Sanskrit jurisprudence. Thank you again to the organizers for the honor of addressing.
Thank you, Professor, for your such an illuminating and enriching address. Your insights have truly set the tone for the conversation ahead. Before we move forward, let me acknowledge the tireless effort of Dr. P.A.T. the convener of this conference, Dr. Udri Shah, the co-convener of this conference, Dr. Rapti De, Dr. Shampa Bormon, and their team members. Also, we thank the student volunteers to make it reality, and also thank the principal madam and the IPSC convener and the ICSC sir for generously sponsoring this conference. Before we proceed, let me briefly outline the structure of this conference for the day one. We have two technical sessions in this auditorium. One is on the gender, justice, and ancient India, and second one is on the Dharma and law Vedic times. The second session will start after the lunch, and we also have a parallel session after lunch for the online paper presentation. So we are already running late, so we hope it will take me to start the first technical session, and we have 25 minutes for each presentation. I thank you, ma'am.
Sir. On for
So, in our first technical session, the theme is gender, justice in ancient India. Professor Davis will chair this session, and we have two eminent speakers. One, Professor Tapan Kumar Basantia, who is the Dean School of Education, Jharkhand Central University, and Dr. Anita Bandyopadhyay, and Professor and Dean of the Department of Sanskrit, University of Kolkata.
জায়গা আছে ঠিক আছে এন্ডমেন্ট গুলো আমি নেবো না আমি এখানে আছি আমার প্রথম করে লিঙ্ক করতে পাঁচ ছয় দিকে যাই
আবার রেকর্ড হচ্ছে ফোনে আবার
হ্যাঁ?
ভিডিওটা ফোনে হচ্ছে, এটা তো বেশি একটু জায়গা নেই আমার
এটার সঙ্গে এটা কি করে
অনেক জায়গা নেই, এটা তো
এটা
ওয়াইফাই যোগ আছে,
না ওই ফটোটা এখানে আসছে কিন্তু
ওয়াইফাই কানেক্টেড আছে, ওয়াইফাই দিয়ে কানেক্টেড আছে।
almost like this. No, no. You can decide it. Either it will be 20 plus 5 minutes or the same with the both speech.
I keep it here. Okay.
Fine.
মহল তো খালি হয়ে গেল।
Mute করে দেবো, should we mute?
এই তোমার কি সরি লস কিসের জন্য দিল এক্সারসাইজ নিচে থেকে ফাইল নিয়েছো ফাইল
We are going to start our technical session one. And we already have our chairperson, Professor Davis and guys. We also have two very eminent speakers here, Professor Dr. Priya and Dr. Anita Gondapata. We have added four speakers here, four presenters who have submitted their paper to be presented here. And I'm going to repeat their names so that they stay prepared. K.S. Savita, Ovita Das, Subhomar Pahari, and Sushi Kane. I hope once the speakers they have their speech, I will request you to come one by one and announce your names. Please come and say them. Okay. Hello. So we are, I should be saying good afternoon here. We are just at Red Blue. We are going to start with our first technical session that is on gender justice in ancient India. And the session is going to be chaired by Dr. Professor Davis. We have two very eminent speakers and four paper presenters. Now, before we start this session, I would like two of our students to come forward and felicitate Professor Tapan Bashantya and Professor Oliver Gondapati. Professor Gondapati. Over to you, Professor Davis.
Okay, good afternoon. I've been given the honor to chair this first session, technical session on gender justice in ancient India. The speakers have kindly agreed to stay to time, and I promise that I can keep them there. So we will hear first from Professor Tapan Kumar Basandia, who's Dean and Professor at the School of Education in Jharkhand, Central University. So he will speak to us for 20 minutes or so, leaving some time for questions.
Good morning to everybody. At first, I am very much thankful to this college, such a historic college, organizing this international seminar. There are two important aspects of this seminar. One is the international seminar, and this seminar is being organized by the three departments: the Department of Sanskrit, Department of History, and Education. So this is a landmark, and I thank the principal of this college, Sutappa Madam, that the chief guest and president of this session coming from a long distance, Professor David, and IQAC coordinator, then president, and all the participants, hosts and guests, both I congratulate and thank for being the part of. My discussion will be on gender issues and justice in the higher education perspective. And that is based from what educational perspective, because in the inaugural session, what discussion was done on the justice, justice, social justice in ancient India. Talking about Mahabharata, talking about Ramayana, that how justice is preached through those great epics. We say about Indian knowledge system, what I understand, there are three important things. One is there are three important things: Varna Vyavastha, Ashram Vyavastha, and Purushartha. Because in our discussion, two important points we have discussed. One is Varna Vyavastha and Ashrama Vyavastha. But there is concept of Purushartha. There are four human goals: Dharma, Artha, Kama, and Moksha. There is a saying, प्रथमे नार्जितं विद्या द्वितीय नार्जितं धन तृतीय नार्जितं कर्म पुण्य चतुर्थ किं करिष्यति. That means if in your first phase of life you will not go for uh, uh, earning dharma, in second phase it will not go for getting, will not go for getting But Indian philosophy, Indian knowledge system, Indian life system, Indian way of life based on dharma, artha, kama, and moksha. These are the four purusarthas, the four rules of life. And to achieve these purusarthas, we have four stages of life. That is one from that is brahmacharya, grahastya, vanaprastha, and sannyasa. Because in brahmacharya stage, we focus more on dharma. In grahastha stage, we focus on three purusarthas, that is dharma, artha, and karma. In vanaprastha stage, we focus on dharma as well as somewhat moksha, and in sannyasa stage, we totally focus on moksha. And to achieve this, that we are in Bhagavad Gita, there are many, we can say, yogas are there, you can say that Jnana Jiva, Dharma, that is Karma Yoga, so that so many that Bhakti yogas are there. But Indian philosophy, Indian tradition, Indian culture system always says that equality between men and women. It is a true fact because always we say because the wife is called Sahadharmini and no good work can be done or any kind of dharma related thing cannot be done without that wife. It is true. But what is the real picture? Real picture of gender justice in our system we will discuss because our past is very rich. We know because all if we analyze the Indian philosophy, we have six schools of philosophies which have been created in India. We can say evolved in India. You can say Sankhya, Yoga, that means Mimamsa. Yes, six. So many philosophies have been evolved in this country, and this country had so many ages. If we analyze, we can say Vedic age, Upanishadic age, Dharma Sutra age, Ramayana age, Mahabharata age. So many ages are there, and in each age there are some great events and great writings and great way of life. It is true, but the point is that how far in practice we do, how far gender justice is there in practice, in reality. I show you the database. Many times we believe that in our country, because our country theory tells that we are equal. But what happens in practice? What is the contemporary justice? And many times we believe that in our country we have gender inequality. What is about the other countries in Western society? What is the status of gender justice there? What is the true picture of gender justice? That is, I'll tell about the research-based evidences and database evidences. Because only theory, because life is always based on practice, not on a theory. So let us go ahead. See, when we say about the gender, the concept of gender, male, female, and transgender, you must be knowing these are very common. So far as gender aspects are concerned, we have three kinds of gender. One is male, female, and see, there are two perspectives so far as gender is concerned. One is biological perspective, and another is sociological perspective or social perspective. Basically, gender, when we say gender as a biological perspective, it is related to sex, and it is biological differences are there between men and women. You all of we understand and we also admit. But so far as a sociological perspective is there, we because that is totally value loaded. Sociological perspective is always value loaded. That based on our work culture, that is based on our thinking process, that is based on our behavioral pattern, that is based on our reality of understanding and doing the things. Because biological differences, we may not make the difference, but sociological perspective, sociological differences, we can reduce that differences. When we think about gender equality, practically it is gender equality, but not equality, because biologically men and women cannot be made same. But so far as the sociological perspective is concerned, we can minimize the differences so that we can lead a better society. See, then let us see. But in our society, we find that gender issues are there. That is, we use the terminology like gender discrimination, gender disparity, gender inequality. We use the terminology. See, uh, so far as gender issues are concerned, there are two perspectives. One is historical perspective is there, Another is neutral perspective is there. Historically, it is seen that always and throughout the world, gender difference is there. I'm not telling, data are telling, and I'm telling because I'll show you some sort of the data where that how much gender differences are there. Neutral perspective. What is that neutral perspective of gender issues? Because many of you whether know or not, many times gents are also victimized by the ladies. It is true. That is why in India that Purush Commission is also coming up. It is also true. And women are also victimized by the men. This is because it is a here the gender issue concerned with that one gender affecting the other gender. This is the neutral perspective of gender because of gender differences. But historically, what happens? Always there is a women is being that exploited by the men that history tells. Because we'll discuss that further. You can see my first sentence you can say in the context of understanding gender. Though no research has proved that cognitive difference between male and female doesn't exist. There is no research till today in this world that the cognitive differences is there between male and female. But still, why there is a gender difference in this society? This is a very vital question for all of us to understand because no research, because I have also done some sort of research in the field, this field, but hardly I found that any research said that the cognitive difference is there between male and female. But it might be because of lack of resources. It might be because of lack of opportunities, because women have not come to the forefront in any field, in many fields in the past days, not because that they are weak in a cognitive manner, but because that they had lack of opportunity. For example, whenever we want to make a woman a scientist, because apparatus should be used by the women. Thereafter, women can be a great scientist because the science always needs experimentation, but always you can say the family binding, social binding, and other such cultural binding many times hinders the women to be the part of the science exploration process. In the past days, in reality, see, lion's share of the societies of the world, they are male dominated. Many times we believe that in our country this difference is there, but in many countries this difference may not be there. But in my research, I could able to find that many of my co-workers also they have done the research. We have analyzed the data from the whole world, and we found that in each and every society there is a gender difference. It is not the case of Indian society or Asian society or the society of the developing countries. Rather, in the whole world, there is a gender difference. See, gender difference is just like a caste issue, class issue, religious issue. It is basically a social stigma. Basically, a social stigma, and gender is the most pervasive form of inequality. See, so far as caste system is concerned, it is basically related to India and it's related continent that countries like you can say Nepal or Bangladesh or Pakistan or somewhat Pakistan or the very countries of the India. But when we say that gender issue, this is an issue of the whole world, like sometimes religious issue and other issues, because it is not limited to a particular area of the country world. Rather, it is an issue of the whole world, and gender issue that you will find in all the social setup. You will not find a one setup in this society where gender issue is not there. It may be in education, it may be in your workplace, it may be in your family life, it may be your political system. You can see in politics, you count how many politicians are women. That means holding the post of MP in India, member of parliament, or you can say MLA, member of legislative assembly. Always you can that always women constitute 50% of the total population. All of you agree with me or not? Almost. In some societies, it is more than 50%. In some societies, it is less than 50%. It is true. But whether they have 50% representation in all cases, definitely not. Definitely not. Because we are working in university system. Whenever we count, if we have 400 teachers, only you will find 50 or 55 female or 60. It will not even touch 30%. The reason, what is the reason? Because we are telling that in ancient India, we had that so many rules, so many laws for gender equality, this, that, everything is okay. But what is in practice? How many vice chancellors are women? How? Never. In no state you can find it is touching even 30%, I think, because from the outside that I can say. Because I found that one of my students did his research on this one, found that in almost cases, in major cases, always that only top level posts are being being that held by the that gents. That means male counterparts. You can say how many professors are that women in a university? If you get that 100 professors, you will hardly find 10 or 15 professors there. Hardly 10 or 15, hardly. That is, I mean, using the terminology hardly. They are that women. So far as professors are concerned. How many women are associate professors? This is another question. Though they constitute around 50% of the entire population, whether their proportion is 50%, definitely not. How many assistant professors? It is also the same question. But you can say that in the school level, sir, you can find that large number of women are school teachers. They have a different reason behind this one. How the appointment is done, what was the, especially in public schools and others, you can find that women are there. But in practice, how many registrars in a university are women? Hardly you will find 5%. I don't think that you will find 5% registrars are women. How many pro vice chancellors? How many? So how many pro vice chancellors are women? How many that deputy registrars? How many? So in every section, women representation is low. Not in India, but in all the Asian countries, but in whole world. This indicates that there is a disparity so far as that women representation is concerned in any field. So whatever may be our history, I am forgetting the history, but reality this is going on. See, then next you can see patriarchal family and matriarchal family. Okay, and patrilineal family and matrilineal family in India, except this Garo society, except Garo, and especially in Meghalaya, you will find it. Meghalaya in Garo, Khasi, Jaintia, in those areas, some societies are there. Only those societies are material, that matriarchal. Besides that, in India, every society is a patriarchal society. I can say this was a tense because always that in tribal society, especially in tribal societies, you will find that some tribal societies are matriarchal, where that women, because even if for resource, that means in Meghalaya, I can say all the properties that the parents they go to the women. So in some tribal types in Meghalaya, but in not in others. But nowadays, government has some sort of rules in the recent time to channelize the resources to both men and female. But it is in true and it is in practice. See, there are basically two spheres of gender issues. One is family and society. What we know in family we find gender issues and society in gender issues. Okay. Another very vital question for this creating this gender issues also, who are responsible for that one? Whether male persons are responsible or female persons are responsible. I can say one thing that once that one chief minister of Odisha was there, that she told one sentence which created a lot of problem among the women society. What she told that so when there is a torturing of women in a family, most of this torturing is being done by the women, not by men. And this statement was given by Nandini Satpathy, who was the first, that means already that she is no more, but she gave this statement in major cases. He will, it, huh? Okay, major cases you can find that this is the issue. What I actually want to tell that, so in India, that means even if for gender issue, The same gender is also that responsible. My point is that it is not always the opposite gender that create the problem. Same gender also create the problem with that. And because of this, you can say in family, you can find that dowry system, domestic violence, girl child marriage in an early age, then gender-based harassment, gender-based exploitation, gender-based abuse and torturing, gender-based division of labor. You can know that means in which work that women are utilized, that they do the which work and the what men do, that undue criticism based on gender, then tradition based on devaluation of women, তারপরে undue preference to the gents than the ladies. These are also emphasized. So in the society or these are in practice because of the gender issues. See, there is a problem in using the power, using the resources. So because of the gender differences, because you can see that land, property, wealth that is always provided to the gents, that means son, not the daughters. So even if that women they have less that access to the information, even if they are kept away from decision making, you can say that in a family, whenever decision is taken, major decisions are being taken by whom? Taken by the that household, especially male persons. You can say women are always that engaged in the domestic duties and son preferences. Even if mother gives the preference to the son, not to the daughter, you can see how painful this one. A mother gives the preference to the son, not to the, because if the mother has a son, the mother becomes happy, and if the mother has a daughter, many cases. I'm not telling the exceptional cases. I'm telling the some cases. You can find this one. You can see it brings what are the problems that are created in the society, that leads to political instability, cultural degradation, retardation of economic growth. Why? You can see when the 50% people of a country or a nation or the world, if they are engaged in a very small work and they are not given to earn more, automatically there is a degradation of the society. That is, women, whenever the women will get the equal status, then there would be no much problem because it affects the social personal life. It ultimately leads to the national development and global development, and it reduces also well-being. See, Indian social structure practically, if you will see, that is man dominated and male dominated. Asian social structure, you may take any Asian country, you will find also this is also man dominated. And global perspective has also, you will find that it is also man dominated because the time is very less. See, if we will look to the higher education system, we can find that even if in appointment or recruitment, promotion, work practice, always you will find that male has a preference. Even if admission of the student, you can see admission of the student enrollment, even if achievement, now that the achievement of the student is increasing because of the much emphasis is given on girl child education. Because slowly the girls are coming up, but uh, but in every cases you will find that there is a difference. So we can say even if in discipline, maintaining discipline, institutional activity, teacher-taught relationship, providing benefit to the students, providing educational environment, always the boys get the better seat than the girls. So, but what are the causes of these gender issues in education system, especially because of there is lack of security, lack of awareness, customary practices that affect a lot to the higher education system, and it creates a lot of that gender related issue, conservative attitude of the family and the society itself, and a lack of proper regulation. Because obviously हमारा women that our women they cannot go on the road that in the midnight. So this indicates that many times the women are less qualified because of their family engagement, early marriage, and other things. They cannot have a better position, and they may not have a better position, as well as I can say uh, work culture in the system. Okay. See, some of the research studies you can say I specifically, two studies have been conducted. That one study has been conducted in Northeast India, where it was found that women have very poor enrollment in comparison to the men. This is a research study conducted by Dhar 2015. Another study was conducted in Manipur University where 50% women don't have residential accommodation facilities than the men. You can see in rural Bengal, 50% women are illiterate, 20% have only the basic knowledge, not and 30% are literate up to class 6. One study has been conducted in Australia where it was found that in Australian universities, women are under represented in senior academic positions. So this study tells. Then another study conducted in European societies, it was found that overall unemployment rates only that means for women it was around 4.8%. For men it was 2.8%. That women unemployment is more than the men. And another study in Nigeria, it was found that there is relatively high prevalence of sexual harassment in the universities of Nigeria. In UK, another study conducted in UK, it was found that only 50%, 15% professors are professors in the universities, they were women. That study was in 2003. In German, only it was only 8.6% attend the highest grade of professorship. You can see among the 100 professors, only 8 professors are women. This is the case of German. Forget about the other countries. So in Netherlands, you can find there is a gender difference in selection and recruitment process. This I'm not telling. The studies are telling. Even if in Sri Lanka, you can see after half century of the establishment of first university in Sri Lanka, university educated women still continue to be the unemployed for the longer period, unemployed in lower position and has difficulty in getting entry into the management position. Always the management positions, high positions are being taken by the that male counterparts. You can see. So in other countries, even if in Israel, you can see in Israel because of the prevailing gender stereotype, female students choose predominantly humanity subject. They don't allow, they are less allowed for science subject. This is the case of Israel, which is considered one of the developed countries of the world. So we can find that why to address the gender issues and because what type of justice they need? They need because especially gender justice, what type of gender justice we should provide and why we should provide. Because for achieving democracy, it is required. For academic and administrative reform, it is required. For leading social cohesion or social justice, it is required. Achieving gender-based liberty, it is required. Achieving gender parity, it is required. Achieving national development and global development, it is required. Approaches. See, there are two approaches behind us. One is motivational approach, another is cohesive approach. Always cohesive approach is not better and it is not always that suggestible because always our approach should be motivational approach to maintain the gender equality because we can manage it through motivation, we can manage it through proper propaganda, we can manage it through proper awareness, not through by force, by legality. Okay, this is the best approach. I can say that that is, I can say cohesive, forceful approach is not better. See, at the international level, prohibition against sex discrimination was first articulated in United Nations Charter 1945 and later reiterated in Universal Declaration of Human Rights in 1948 and the International Convention of Civil and Political Rights adopted in 1966 guarantees equal protection of the law for both sexes. Okay, you can see, sir, only 2 minutes. Okay.
2 minutes.
2, 3 minutes. Okay. Strategies we can go for some of the strategies like providing special facilities, relaxing some eligibility criteria for them. We can give them more rights and freedom. We can make the people of the society more conscious to achieve the gender equality to both male and female. Moral support is more important for achieving gender equality. Financial support for them, equal work, equal pay. Many, especially in private organizations, you will find that women are paid less than the men, and they are always given a substandard work than the men. So scholarship, fellowship, others should be given. So that reservation for women, establishment of special department and institution. Your college is the best example because it is also a women college. So that workshop and training program for achieving gender equality, defining women's self-help group. I'm giving the example of state of Odisha. This women's help group is working very well in the state of Odisha. So judicial activism, the present discussion, the whole center of discussion is judicial activism for achieving gender justice and defining the role of women. That means women activists for achieving gender equality and defining the role of education, especially for achieving gender equality. So that is why you know that the government has also given some special facilities for achieving like that single girl child for single girl child. Some sort of facilities are given by government. Women cells and women commissions are created. Gender sensitization cell is created in every institution. Then you must be knowing about that Kasturba Gandhi Balika Vidyalaya. That committees are required in every institution for against the sexual harassment. So Beti Bachao, Beti Padhao Andolan, that means scheme you must be knowing. Mahila Shakti Kendra, then Sukanya Smriddhi account. So many account that programs or what I can say that programs are being launched by the government to achieve the gender equity and gender justice. So 9 schemes of UGC you must be knowing that which are very important for achieving gender justice. Okay, thank you.
Okay, friends, we're going to keep moving. Thank you, Professor Basanke, for your talk. Next, we have Dr. Anindya Bandapatiya from the University of Kalyani.
Let me first express my deep gratitude to all the members of the organizing committee and definitely to the chairperson for providing me with an opportunity to present my paper. From ownership to obligation, Medhatithi's legal reading of Manu's guardianship. When a ship begins to sink, the ancient maritime code of West dictates women and children first. This unwritten rule dating from the mid 19th century has no foundation in law, yet it has shaped our moral instinct about vulnerability. Across cultures, the impulse to protect women and children first emerges not merely from sentiment, but from a deeply rooted perception that they are the most at risk. In moments of disaster, this ethic of care transforms into a principle of social conduct, one that blurs the line between protection and dependence. India, too, has long been preoccupied with this moral question: how to protect it and at what cost? From the verses of Manu to the clauses of the Indian Constitution, the discourse on women's protection reflects a continuous negotiation between equality and care, independence and guardianship. Article 14 of the Constitution guarantees equality before law, and Article 15 forbids discrimination on the ground of sex. Yet, in the same breath, Article 15, subsection 4, authorizes the state to make special provision for women and child and children, an exception that echoes an ancient anxiety that equality, if left unqualified, might expose the vulnerable to harm. The logic of protection, therefore, persists as both a constitutional safeguard and a philosophical inheritance. But this inheritance is far older than the modern state. Over 2000 years ago, Manusmriti declares Pita Rakshati Tomare, Varta Rakshati Yogare, Rakshanti Sthavire Putra Nastri Swatantra Agati, as Professor Oliver translated. Her father guards her in childhood, her husband guards her in youth, and her sons guard her in old age. The woman is never fit for independence. This single verse has provoked centuries of interpretation, outrage, and defensive. It epistomizes patriarchal domination, a textual foundation for women's subjugation in Hindu law. To others, it expresses an ethic of familial responsibility embedded in the social fabric of ancient India. The truth, as always, lies in the interpretation. In India, the law was never static text. It was a living hermeneutic shaped by commentators who mediated between scripture and society. Among these, Methoditi of Kashmir, one of the earliest and most influential commentators on the Manavadharma Shastra, stands apart for his nuanced reading of this very verse. Far from endorsing blind subordination, Meghalti transforms Manu's statement into a judicial principle of care. The duty to guard a woman, he argues, does not signify ownership but obligation, a preventive and protective injunction against harm. In this paper, I revisit Medhaviti's exigencies to explore how his interpretation reframes the idea of dependence within a gendered legal imagination. Can we read guardianship not merely as a patriarchal chain, but as a moral and judicial responsibility grounded in the social ethics of protection? To ask this question is to engage with two interesting discourses, the gendered body as the subject of law and dharma as the interpretive matrix of justice. Between the ancient Shastra and modern gender theory lies a shared problem, the tension between care and control, equality and exception, autonomy and safety. It is within this fragile tension that Medhati's voice from early medieval Kashmir offers an unexpected insight, one that both echoes and interrogates the timeless question, what does it mean for a woman to be never fit for independence? Um, the Manusmriti's journey into modern consciousness begins paradoxically with colonial admiration. When Sir William Jones translated the text in 1794 as the Institutes of Hindu Law or the Ordinance of Manu, he introduced to Europe what he called the most venerable code of Hindu jurisprudence. For the first time, a non-European legal system was presented as a rational textual corpus. Jones' translation and George Woolper's later version gave Manu canonical status, not only as India's lawgiver, but as the principal lens through which Europe interpreted the moral and legal life of India. This philological fascination, however, carries a double edge. The same text that earned admiration for its antiquity soon came to represent in colonial and later nationalist discourse, the essence of India's supposed social backwardness. During the 19th century, Orientalist scholars cited Manu to demonstrate the rigidity of the caste system. Why? Indian reformers like Ram Mohan Roy and later B.R. Ambedkar rated it as a symptom of systematic oppression. Ambedkar's public burning of Manusmriti in 1927 and later the symbolic burning of its copies at the Rajasthan High Court in 2000 turned the text into a political problem, a scriptural scapegoat for patriarchy and caste discrimination. In feminist and Dalit critics, Manu has thus become a contested signifier, both the lawgiver and the oppressor. Passages like this, what I quoted before, are cited as proof of patriarchal subordination, while conservative interpreters defend them as expressions of timeless familial ethic. Between these poles lies the real hermeneutic challenge to understand how texts like Manavadharma Shastra echo the gendered order of their times
and how later commentators reinterpreted those codes to accommodate shifting realities. For today's scholars, the challenge is neither to condemn, not to canonize Manu, but to contextualize him. The Mahabharata Shastra is not a timeless scripture, but a historical text born of a moment of social negotiation. It is its vision of women's independence reflects the attempt of an ancient legal imagination to define order through relational ethics. Its later reception from colonial courts to feminist critics reveals how the same text has continued to generate meaning, conflicts, and reinterpretation across centuries. To revisit Manu's that code, therefore, is to engage with more than a single verse. It is to confront the entire history of how societies have sought to reconcile protection with autonomy, law with care, and justice with hierarchy. The text survived not because it answers these questions, but because it continues to ask them. In the following section, I will examine how an early medieval Kashmiri jurist, equipped with the tools of Mimamsha and writing within a sophisticated scholastic milieu, approaches the significantly approaches and significantly reshape one of the most contested verses of Num. Situated within the dense historical and intellectual landscape of early medieval Kashmir, Meghaliti does not merely echo the orthodox formulation in he, what he inherits. Instead, it deeply sophisticated deploys the sophisticated hermeneutics machinery of Mimamsha to recast the verse not as a claim about women's inherent incapacity, but as a carefully constructed legal framework of protection anchored in social responsibility and juridical duty. Milwaukee begins with a precise semantic analysis of the key term eruption, girding. He argues that in this context, the term does not denote control, confinement, or ownership. Rather, it signifies anartha pratibhata, the prevention of harm before it occurs. Crucially, anartha for Meghaliti include more than physical danger. It encompasses any form of harm that may arise if a woman or her property is misused, whether through social vulnerability, economic exploitation, or actions that fall outside accepted norms. Guarding, therefore, denotes an obligation to avert foreseeable harm and ethic of responsibility placed upon those male relatives who, at different stages of her life, stand closer to her. This interpretive move shifts the conceptual ground from domination to obligational ethics, a key principle in Dharmashastra jurisprudence. Rakshana is thus a legal duty rather than paternalistic enlightenment. A cornerstone of Meghaliti's hermeneutic strategy is his instance that the verb rakshati, gird, though expressed in the present tense, should be understood as injunctive, not descriptive. This follow a foundational Mimamsha principle in ritual discourse. The present tense often functions as a vidhi, prescriptive rules. A classical illustration frequently invoked in Mimamsha is the expression Regin Prokshadi. Literally, he sprinkles the rice grain. In ritual context, however, this must read normatively as he should sprinkles the rice grain. The present tense thus equal obligation, not narration. Applying this principle in this verse, Nehadidi argues that Rakshati must be understood as Rakshat, should gird. The verse therefore expresses what father, husband, and son ought to do, not a factual claim about what they necessarily do in practice. In this shift from descriptive to normative, Manu's line becomes a legal perception of duty, not a sociological generalization. Nehati carefully to point out that Manu's tripartite division of women's life, childhood, youth, and old age, is not meant to assign exclusive authority to different guardians, but to indicate who bears the primary responsibility at each stage. The framework in this reading is one of graduated duty, not hierarchical control. Virginity, Omar, he explains, denotes the period before marriage. Youth, Yovana refers to the time during which the husband is alive. Yet, this does not mean that the father or son relinquish their obligation once the husband enters the fertility form. On the contrary, Medhaviti insists that all male relatives remain responsible for her protection at all times. The verse simply marks whose obligation is strongest in each phase of her life. Seen this way, the passage is not an attempt to curtail female agency, but a reflection of Dharmashastra's broader ethic of shared familial guardianship, in which social responsibility is distributed across kinship lines rather than concentrated in a single individual. This relational model, so characteristic of pre-modern legal system, underpins Medhaviti's effort to read the verse as a coordinated structure of duties rather than a rigid system of control. In his commentary on the preceding verse of this particular verse, Medhaviti prepares the hermeneutic ground for understanding this verse. His analysis shows a social philosophy shaped by the practical logic of Dharmashastra, rather than by any belief in women's inherent incapacity. He clearly distinguishes between a woman's non-independence in matter of dharma, artha, and kama, and the entirely separate notion of guardianship. For Nirvaditi, activities related to religious duty, control of wealth, or sensual enjoyment are legally sensitive and socially consequential. Decision in these areas, therefore, require household oversight because ritual responsibility, property, and familial honor were closely interwoven in his social world. When he cautions against unregulated participation in enjoyments such as singing or revelry, the concern he um, the concern he explicitly notes that enjoying such pleasures within home, even drinking or festive indulgence, does not itself result in moral harm. What worries him is not is what worries him is not the pleasure, but the vulnerability produced by uncontrolled public interaction. Read together these observations reveals a coherent legal logic with Aditi 6 to preserve household stability and prevent foreseeable harm within a relational social order, carefully distinguishing between restriction on legally consequential duty of protection. At this point, we must confront a crucial paradox within the Dharmashastra framework of guardianship. Manu in 947 famously declared Sakrit Angso Nipatati, Sakrit Kanya Padipaliyate, Sakrit Aga Dadami iti, Trini Etani Sakrit Sakrit. As Oliver translated, once is a partition made, once is a maiden given, once it is said, I give, these acts occur only once. This formulation appears straightforward. Once a daughter is formally given away in marriage, the father's legal role should, in theory, end. Yet this creates an immediate doctrinal puzzle. If the kanya is truly given away, given at once, how can her father, according to other verses, still bear responsibility for her protection after marriage? How can guardianship persist when the act of giving seemed to terminate all prior claims? The Sanskrit commentary reveals the sophistication of Medhaviti's juristic reasoning. He begins by noting that the phrase Sapit Kanya Pradiyate might, on its surface, suggest a complete transfer of right, much like the giving of cow or other property. But he argues the analogy breaks down upon closer scrutiny. Unlike property, a daughter embodies two distinct relationships. One is a natural and permanent bond of kinship, that is apatta apatta vadabhava, and the legal relationship of guardianship, that is swaswami sambandha, the latter of which alone is extinguished at marriage. Thus, while the father's proprietary authority ends with the ritual of panipravana, this kinship bonds does not. This allows Medhaditi to reconcile Manu's injunction that giving transfer the husband's right of guardianship but does not erase the father's continuing moral stake or residual responsibility. In effect, Medhaditi transforms Manu's Tar's declaration into a layered legal doctrine, one that differentiates between biological relationship and judicial authority, stabilizing the system of guardianship while preserving the coherent, coherence of the Shastric norms. Within the argument of this paper, this analysis is crucial. It shows that even in a text often um, caricatured as rigidly patriarchal, early medieval jurists like Medhaditi were developing precise legal categories to navigate the tension between kingship, marriage, and protection, tensions that echo into modern debate on gender and legal personhood. Medhati's interpretation of Manu's discourse offers far more than a technical elucidation of a challenging verse. It demonstrates the capacity of Dharmashastra tradition to reinterpret received norm through multiple interpreting frameworks. His reading synthesizes the analytical precision of Mimamsha hermeneutics, the socio-legal realities of early medieval Kashmir, and an ethic of relational responsibility grounded in kinship and familial duty. Seen through this lens, Medhatiti emerges not merely as an exegesis of Manu's text, but as a jurist who redefines the terms of autonomy, protection, and social responsibility within the Dharmashastra tradition. His interpretation illuminates the evolving architecture of gendered norm in Sanskrit jurisprudence and offer conceptual resources that continue to inform contemporary interdisciplinary debates on gender law and the ethics of care. In the conclusion, I like to say that placed within the long array of global legal history, the movements without regulating the autonomy of women, and it's without regulating the autonomy of women. Aristotle's construction of the woman as an incomplete man, Roman tutela mundanium as a lifelong guardianship, masked as benevolent protection, and the Confucian doctrine of the three obediences all echoed this anxiety in different civilizational idioms. Manu's uh, uh, triad model of guardianship, therefore, does not stand alone. It participates in a global juridical reflex that seeks to stabilize society by circumscribing female independence. Yet the history of Dharmashastra shows that even within such system, interpretation not in area in the engine of legal life. Medhadithi's 9th century Manu Bhashya exemplifies this vitality. Guided by the analytical rigor of Mimamsha, it reconfigures Rakshana not as a claim of domination, but as a principle of preventive responsibility and obligation to avert harm rather than an assertion of ownership. In doing so, he marks an internal shift from status-based independency to a more relational, duty inflected model of care. His commentary does demonstrate that the Dharmashastra tradition proposed its own mechanism for conceptual redefinement, negotiating inherited norms through subtle distinction in meaning, agency, and obligation. Modern legal order, however, inaugurates an epistemic rupture, while the rise of the constitutional state, the locus of authority shifts from lineage and ritual to individual personhood, from guardianship to right, from prescribed dependence to judicial equality. Article 14 and 15 of the Indian Constitution emerge precisely from this historical turning point. They are not rejections of India's past, but jurisprudential responses to it, responses to a long tradition in which gender protection was um, structurally entangled with hierarchy. Constitutional equality is required not because the past was unintelligent, but because the conceptual world that produced the past no longer addresses the society realities of the present. To read Manu and Medhaditi together is not to revive or to excuse ancient doctrines, but to understand the historical logic that made them meaningful in their own time, and to recognize why that same logic makes modern equality indispensable in our justice in this broader perspective uh, is never a destination, but an evolving conversation, a dialogue between inherited norms, contemporary ideals, and the future we strive to imagine. Thank you.
So I know we're all very eager to get to lunch, I think. So but we have four student papers, if I'm not mistaken. So I know that we have four presenters coming. So could I invite you to come in first? If you can present for a short bit. Each presenter will get 5 minutes to present their paper. Okay? Coming. Your second members. Kavita here.
Very good afternoon to one and all present here, respected dignitaries, faculty members, and students. It is my privilege to speak on the theme from Dharma to democracy, ethical roots of constitutional values and justice in Indian political thought. Um, Far from being a modern invention, Indian democracy stands upon millennia of ethical thought shaped by the Upanishads, Dharmashastras, Arthashastra, Buddhist and Jain philosophy, and later by Gandhi, Ambedkar, and Swami Vivekananda. This paper explores how the Indian Constitution embodies ethical ideals that matured through centuries of intellectual evolution, culminating in a vibrant, democratic ethos that emphasizes both rights and duties. This paper explores to trace the ethical and philosophical foundation of the Indian Constitution through ancient Indian political thought, and also to analyze how concepts such as dharma, nyaya, and Raj Dharma shaped modern constitutional values, and also to examine the awareness of Indian knowledge system references in constitutional discourse, and also to provide an analytical bridge between classical texts, Upanishad, Arthashastra, Dharmashastra, and constitutional ideals such as justice, liberty, equality, and fraternity. The methodology, this study adopts a combined descriptive as well as analytical methodology, and the descriptive method is used to present the evolution of ethical principles in Indian thought by examining the primary text, Upanishad, Arthashastra, and Dharmashastra. The analytical method critically evaluates these ethical foundations in relationship to contemporary constitutional values, judicial interpretation, and democratic practices. And comparative analysis is employed to access the continuities and transformation from classical philosophy to modern constitutional justice, enabling a deeper understanding of India's ethical, political trajectory. So I have gone through so many reviews. In that, I have seen one, Amartya Sen, 2009, highlighted India's argumentative tradition and concepts of Nyaya and Niti, arguing that they enrich contemporary democratic reasoning. And so many other people I have viewed, and also theoretical framework, the paper draws from normative political theory. The theoretical pillars guide the analysis, dharma theory, Raja Dharma theory, and constitutional morality as conceptualized by Dr. Bhimrao Ambedkar, focusing on liberty, equality, justice, and public reasoning. Foremost, I would like to quote on Dharma as the moral foundation of governance in India. In Indian political thought, Dharma occupies the central place as the moral compass guiding rulers, institution, and society. Far beyond the religion notion, Dharma signifies righteousness, duty, moral order, and the principle that sustain harmonious coexistence. So, classical Indian texts present Dharma as a universal ethical law that binds both the ruler and the ruled, making governance an inherently moral enterprise rather than merely an exercise of power. The Upanishads articulate Dharma as moral truth that upholds justice, compassion, and truthfulness, asserting that the legitimacy of political authority rests on moral conduct. The ruler is seen not as a sovereign in the absolute sense, but as the protector and practitioner of Dharma. This idea is further elaborated in Dharma Shastras, particularly in Manusmriti, where the king is described as the embodiment of Raj Dharma, the duty bound custodian of law and order. Here, governance becomes a sacred responsibility oriented towards the social welfare, fairness, and ethical restraint. Next comes the Arthashastra. Kautilya's Arthashastra reinforces the pragmatic dimension of Dharma in governance. So, while focused on political realism, Kautilya insists that the king's action should align with Dharma, Artha, prosperity, and Kama well-being, ensuring balanced, just, and sustainable governance. He underscores that a ruler who violates Dharma loses legitimacy and social trust, leading to instability. Buddhist and Jainist political philosophies also deepen the moral framework of governance by highlighting ahimsa, non-injury, compassion, and ethical leadership. The reign of Emperor Ashoka stands as the historical illustration of government rooted in Dharma, illustrating welfare orientation, justice, and moral ethics. In modern democratic India, these ethical foundations resonate through constitutional values such as liberty, equality, and dignity. The Constitution emphasizes on rights, duties, social justice, and reflects the ancient ideal that governance must be both legally sound and morally grounded. Foremost, we should understand Dharma. Dharma is not merely a religious law, it is the ethical duty, righteousness, and moral responsibility of each individual in the state. And Vedas describe Dharma as the force that sustains cosmic and social order, Rita. The Bhagavad Gita emphasizes Swadharma, one's moral duty, and Loka Sangraha, welfare for all. 1 minute more. Then okay, fine. So then comes Rajadharma and duties of the ruler, protection of people, welfare state, impartial justice, and Kautilya's Arthashastra emphasizes on the king as the guardian of Dharma, advocates welfare state, and even in Mahabharata's Shanti Parva, Yudhishthira's discussion with Bhishma highlights justice above power, rule based on compassion and equality before law. And here comes constitutional morality and Indian ethical traditions. I would like to quote Dr. Bhimrao Ambedkar's vision of constitutional morality. Ambedkar reviewed the term constitutional morality to emphasize that democracy cannot be survived solely on institutions. It requires ethical discipline and public conscience. So constitutional morality is not a natural sentiment. It has to be cultivated. Next comes Gandhi's ethical philosophy and constitutional morality. Gandhi declared ahimsa is the highest duty. Truth is God. These principles align with constitutional values such as human dignity, Article 21, freedom of conscience, and peaceful civic life. Next comes Swami Vivekananda's ethical universalism and democratic spirit. This statement, each soul is potentially divine, establishes a spiritual basis for human rights, equality of all persons, and non-discrimination, which is similar to Article 14 and 15. 2 more minutes, is it? Then I will go to no, it's just conclusion because it is an findings are there. So conclusion, India's constitutional democracy is not merely a modern political arrangement, but a culmination of centuries long ethical evaluation. The movement from Dharma to democracy is a philosophical journey that integrates moral law with political law. By drawing from Upanishadic humanism, Dharma Shastra norms, Artha Shastra statecraft, and Gandhian ethics, the constitution emerges as a living embodiment of India's deep-rooted moral universe. Thank you.
So, next we have Momita Das.
Good afternoon to all the dignitaries present here, especially my deepest regards to the chairperson. Today, my topic is evolution of women's rights and its impact on women's education in India. It's a joint paper. Uh, uh, Myself, Mohila Dash, Assistant Professor, Kumarganj College, Dr. Dinajpur, West Bengal, and co-presented by Dr. Shul Kumar Baste, Assistant Professor, University University, BT Road, Kolkata, West Bengal. From ancient India, women's rights and consecutive education have witnessed a remarkable journey. That the evolution of their rights has not only promoted their ability to access numerous resources, but also helped to establish their identity as equal to men. So we can see in the coming slides that how the open education gradually came into the Indian soil and then we are here now in these days how where the open education is. As we can say that equal employment, property rights, right to vote, freedom of movement, right to health, getting information about their legal rights, anti-discrimination, etc. are the women's rights. But the right to speak and right to give opinion is the most important women's right nowadays. As per historical background, we can see in 1825 to 1915, there is a movement for the rights and freedoms of women in the Indian society were initiated to uproot several social evils such as preventing widows from remarriage, Satidaha Protha, and child marriage. So, there is a National Federation of Indian Women and All India Women's Conference, which reflects the growth and power of women's position and rights in society. We can say, respected Sarojini Naidu, we all know her, was the first Indian woman to become president of the Indian National Congress. The Indian law prohibited the girl child during this period. After independence, with Indira Gandhi being the first female prime minister of India, the social, political, educational, and economic position of Indian women was further strengthened and with several laws, safety and rights of women were improved. And now we can see in West Bengal, there is also Konyasi University, Diamond Harvard Women's University, also established for the women's education. Uh, we can see the pictures of all respected social reformers and Savitribai Phule and Jyotirao Phule also there as a social reformer who social religious protest against social religious beliefs just like polygamy and Saridaho Protha. Um, and with the help of Widow Remarriage Act, we can say that widow women can remarriage uh, easily. And in 19th century, we can see that Vidoshagar was established dozens of schools for girls in the early 19th century. His fellow reformers, Madan Mohan Tarkalankar and Ram Gopal Ghosh, as also the foster of women's empowerment in Indian society. After independence, sorry, pre-independence, we can see that there was a social evil. There was some social evils like polygamy, child marriage, female infanticide, Satidaho Protha, etc. But we can say that nowadays we can socially struggle and continuous fight. We fight for our social status and we can uplift our position in society. And Indian society pulled women from darkness to light. After independence, some acts was there, like Hindu Succession Act and Hindu Marriage Act, Dowry Prohibition Act. And there are also the in politics, there is also some reservation, like 33% reservations are there. So we can see that in all three tier of Panchayat Raj, there is reservation for women also. And there is also global data that approximately 91.945% Indian has a literacy rate for the women. So, sir, there is also a social and economic impact that child health and the child education is also increased by the impact of the women's education also. There are some challenges uh, like early marriage. As per UNICEF, there are 47% girls married before 18 years age. This is the major challenge. I mean, I think, and There were some schemes just like the Ministry of Women and Child Development has initiated the Beti Bachao and Beti Padhao scheme, and also there is a scheme like Nari Shakti Puruskar scheme, and there is also educational the government tries to educate tribal women to improve the quality of their lives by the Banbandhu Kalyan Yojana. In conclusion, we can say that social reformers has with their tireless effort and contribute of social reformers in India, like Raja Ram Mohan Rai, Jyotiba Phule, Savitri Bai Phule, and many others are there. So we are still preventing the expected flourishing of establishing women's rights in the Indian soil. But this scenario, several government initiative policies and schemes are supporting women to enjoy their rights and enrich educational status for a better future. There are some several references. Thank you.
The next speaker is Shubham Bahari.
Krishna respected chairs and all the dignitaries present in the auspicious Indian Fund. Myself, Dr. Shubhamal Pahari, Assistant Professor, Department of Sanskrit, Vidyasagar College. And there are the option of Bengali language in the brochure. So I want to present my paper in Bengali. So please bear me. My situation is now, I think, গল্প মধ্যে কাপড় যথা বিষয় হচ্ছে অর্থশাস্ত্রে রাজতন্ত্র আধুনিক শাসন ব্যবস্থায় তার প্রাসঙ্গিক কৌটিল্যের অর্থশাস্ত্র প্রাচীন ভারতের অন্যতম গুরুত্বপূর্ণ রাষ্ট্রবিজ্ঞানমূলক গ্রন্থ খ্রিস্ট জন্মের পরবর্তী সময় থেকে বা সময়ে বিরচিত রাজ্য শাসন ব্যবস্থা বিষয়ক এই গ্রন্থটি সমস্ত দেশ কালের সীমা অতিক্রম করে রাজনৈতিক ক্ষেত্রে আজও সমধিক সমাদৃত অর্থশাস্ত্র আধুনিক কালের অর্থনীতিবিদ্যা থেকে ভিন্ন সুব্যাপক ও সুগভীর কৌটিল্যের মতে অর্থ শব্দের দ্বারা শুধুমাত্র সম্পদ নয় তার দ্বারা সম্পদের ও সম্পদ উপযোগকারী জনগণের আধার স্বরূপ পৃথিবী গৃহীত wealth alone is important in as much as charity and desire depend upon oil for their realization. সমাজশাস্ত্রী বলছেন এটা তাই সেই পৃথিবীর অধিগ্রহণ ও পালন বিষয়ক যে শাস্ত্র তাই হলো অর্থশাস্ত্র এ প্রসঙ্গে কৌটিল্য বলেন মনুষ্যানাং বৃত্তিহিরার্থঃ মনুষ্যবতী ভূমিঃ ইত্যর্থ তস্যাঃ পৃথিব্যাঃ লাভ পালনোপায়ঃ শাস্ত্রম অর্থশাস্ত্রম ইতি এই গ্রন্থে রাজতন্ত্র প্রশাসন নীতি কূটনীতি যুদ্ধনীতি অর্থনীতি ইত্যাদি বিষয়ের উপর সুসংহত ও বাস্তব নির্ভর মতবাদ পাওয়া যায় আধুনিক রাষ্ট্র নির্মাণে গণতন্ত্র প্রাধান্য পেলেও অর্থশাস্ত্রের বহু নীতি আজও প্রশাসনিক ক্ষেত্রে সদর্থ নেতৃত্ব হোক নৈতিকতা নিরাপত্তা এবং নীতি নির্ধারণে প্রাসঙ্গিক বিষয়বস্তুর সার্বজনীনতায় সুগভীর চিন্তায় ও বাস্তব অভিজ্ঞতায় গ্রন্থটি কৌটিল্যের অনন্য সৃষ্টি সময় কম, তাই আমি মূল মানে পয়েন্ট আকারে কিছু বলছি। আহ, মূলত যে সমস্যাগুলো আমরা এই প্রবন্ধে মূলত আমি লক্ষ্য করেছি যে কৌটিল্যের রাজতন্ত্র ভিত্তিক রাষ্ট্র ধারণা কি বর্তমান গণতান্ত্রিক রাষ্ট্র ব্যবস্থার জন্য প্রাসঙ্গিক? তার নীতি, প্রশাসনিক কাঠামো, শাসকের গুণাবলী ও নৈতিকতা এগুলি কি আধুনিক সুশাসনে প্রয়োগযোগ্য? আর অর্থশাস্ত্রে রাজতান্ত্রিক শাসন ব্যবস্থা আধুনিক গণতান্ত্রিক ও প্রশাসনিক কাঠামোর সাথে কতটা সামঞ্জস্যপূর্ণ, এবং কিভাবে আজকের রাষ্ট্র পরিচালনায় এর নীতিগুলি প্রাসঙ্গিক হতে পারে? এই প্রশ্নের স্পষ্ট বিশদ ও বিশ্লেষণাত্মক ব্যাখ্যার অভাবই গবেষণার মূল সমস্যা। উদ্দেশ্য মূলত উপরোক্ত এই প্রশ্নগুলোর উত্তর অনুসন্ধান করা, বিশেষত অর্থশাস্ত্রে বর্ণিত রাজতন্ত্রের বৈশিষ্ট্য বিশ্লেষণ করা, রাজধর্ম, নৈতিকতা, ন্যায় বিচার, দক্ষ প্রশাসনের ধারণা চিহ্নিত করা, আর আধুনিক শাসন ব্যবস্থা বিশেষত গণতন্ত্র, আমলাতন্ত্র, নৈতিক নেতৃত্ব, রাষ্ট্র নিরাপত্তার সঙ্গে আধুনিক শাসন ব্যবস্থার তুলনামূলক মূল্যায়ন। আজকে রাষ্ট্র পরিচালনায় অর্থশাস্ত্রের নীতির প্রাসঙ্গিকতাও নিরূপণ করা। লিটারেচার রিভিউ, আমি সময় কম আছে তাই বলছি না, স্কিপ করছি। মেথোডোলজি যদি দেখি আমরা, মূলত এখানে গুণগত গবেষণামূলক কোয়ালিটেটিভ রিসার্চ, নিবন্ধের প্রাথমিক উৎস, অর্থশাস্ত্র এবং তার সংস্করণ সমূহ, এবং গৌণ উৎসগুলি হলো গবেষণাপত্র, সম্পাদিত পুস্তক, আধুনিক রাষ্ট্রনীতি বিষয়ক প্রবন্ধ পুস্তক। অর্থশাস্ত্রে রাজতন্ত্র বিষয়ে আমরা একটু দেখবো যে পাশ্চাত্যের প্লেটো, অ্যারিস্টটলের মতো কৌটিল্য কিন্তু মনে করতেন রাষ্ট্র হলো একটি নৈতিক প্রতিষ্ঠান এবং এর মূল উদ্দেশ্য হলো ধর্মের প্রতিপালন। সপ্তাঙ্গ রাষ্ট্রের প্রথম ও প্রধান রাজা বা স্বামীর যে বর্ণাশ্রম ধর্মের পালনের মাধ্যমে রাষ্ট্রের সর্বসুখ লাভ হয়, আর তা না হলে কর্মসংকর বা বর্ণসংকরের মাধ্যমে রাষ্ট্রের বিনাশ সংঘটিত হয়। তাই রাষ্ট্রের তথা রাজার সর্বাঙ্গীন কল্যাণ সাধনে কৌটিল্য অর্থশাস্ত্র বিশেষ প্রণিধান লক্ষ্য। রাজধর্মের মুখ্য বিষয়সমূহ প্রজাদের কল্যাণ, রাষ্ট্রের শান্তি, ন্যায় বিচার প্রতিষ্ঠা, ঈশ্বর তত্ত্ব। কৌটিল্যের অর্থশাস্ত্রে রাজাকে প্রশাসনিক যে সর্বশ্রেষ্ঠ রূপে প্রশাসনিক ক্ষেত্রে দেখানো হয়েছে। মূলত রাষ্ট্রের কৌটিল্যের যে মানে রাষ্ট্র বিষয়ক মূল যে বক্তব্য, প্রজা সুখে সুখম রাজ্য, প্রজা নাঞ্চ হিতে হিতম। রাষ্ট্রের শৃঙ্খলা, ন্যায় ও শাসন রূপ ধর্ম প্রতিষ্ঠার মূল ভিত্তি হলেন রাজা। বলা হয়েছে ধর্মস্ব মূলম রাজা, জিতেন্দ্রীয় রাজা ধর্মের দ্বারা প্রজাদের রক্ষা করতে সমর্থ হন। দ্বিজিতেন্দ্রীয় রাজা লোকং ধর্মেণ পালয়েৎ। এই ক্ষেত্রে রক্ষক বিষয়ে আমাদের বক্তা অনেক আলোচনা সেখানে করেছেন। তো এখানে দুর্নীতি প্রসঙ্গ কৌটিল্য অত্যন্ত, যেটা সমাজে আমরা দেখতে পাচ্ছি যে রাজনীতির ক্ষেত্রে রাষ্ট্র পরিচালনায় দুর্নীতি তা দমনে কৌটিল্য কঠোর নজরদারি বা প্রশাসনিক দক্ষতার আবশ্যক বলে মনে করেছেন। হ্যাঁ, যথা খলু মৎস্যাহ ক্ষুধার্থাহ জলম জলমতি চলন্তি এব মনুষ্যাহ অপি স্বভাবত ন কশ্চন মনুষ্য দোষরহিত। সময় খুবই কম, আমি একেবারে কনক্লুশনের অনলি পয়েন্ট। কনক্লুশন দেখছে অর্থশাস্ত্র প্রাচীন ভারতীয় রাষ্ট্রতত্ত্বের এক অনন্য দলিল। তার রাজতান্ত্রিক কাঠামো থাকলেও নীতিমূলক ভাবনা আধুনিক শাসন ব্যবস্থায় যুক্তিসঙ্গত প্রয়োগযোগ্য। রাজতন্ত্রের যে মূল নীতিগুলি আজকের গণতন্ত্রের নৈতিক নেতৃত্ব হোক, দক্ষ প্রশাসনিক ক্ষেত্রে হোক, নিরাপত্তা সুশাসনের মূল ভিত্তি রূপে বলা হয়। কৌটিল্য বলেছেন শাসকের ব্যক্তিগত চরিত্র, নৈতিকতা, প্রশাসন, পরিশ্রম, সিদ্ধান্ত ক্ষমতা, ধৈর্য এবং বিস্তৃত জ্ঞানেরও প্রয়োজন। প্রজাদের কল্যাণকেই সেক্ষেত্রে সব থেকে বেশি গুরুত্ব দেওয়া দরকার। সাংবিধানিক অধিকার, ক্ষমতার বিভাজন বিষয়েও বিস্তৃত আলোচনা সেখানে আমরা দেখব। তো সর্বোপরি বলা যায় যে গণতন্ত্রের মত প্রকাশের স্বাধীনতা, মানবাধিকার ও বিরোধী মতের স্বীকৃতি গুরুত্বপূর্ণ। বিপরীতে কৌটিল্যের মতে রাষ্ট্রের নিরাপত্তাই প্রধান, প্রয়োজনে কঠোর শাস্তি ও নজরদারিও সেক্ষেত্রে দেওয়া যেতে পারে। দুই ব্যবস্থার মূল পার্থক্য ক্ষমতার চরিত্রে। গণতন্ত্রে ক্ষমতা বিকেন্দ্রীভূত, কৌটিল্যের রাজতন্ত্রে কেন্দ্রীভূত। তবে উভয়ের লক্ষ্য কিন্তু জনগণের কল্যাণ, ন্যায় বিচার ও রাষ্ট্রের স্থিতিশীলতা। এই সাদৃশ্যই কৌটিল্যের রাজনৈতিক তত্ত্বকে আধুনিক শাসন ব্যবস্থায়ও প্রাসঙ্গিক করে তোলে। সুতরাং নিঃসন্দেহে বলা যায় কৌটিল্যের রাষ্ট্রতত্ত্ব আধুনিক গভর্নেন্স থিওরির পরিপূরক। নমস্কার।
Next we have Shushvi. Please. Mention the name, please. Mention the name. Name. Mention the name. Shushvi. Sushi. Shushvi.
Afternoon, everyone. Please adjust your microphone.
Yeah.
So good afternoon, everyone. I think
Adjust the microphone, please.
is it fine now? Yeah. Thank you. So first of all, I would like to say my deep sense of gratitude to the organizing committee, ITP, and thanks a lot for that. So and it's a picture. I would like to start. Time is very limited, so very short time, so maybe 5 minutes I have been given. So I just would like to brief my presentations and what probably I would like to say. I don't know. I mean, I try to relate with this particular theme. But what I'm trying to highlight the issue, which is very contemporary, and I think all of us probably are talking about it. So just I would like to point out that some of the things that which have come through my research also, and this is my core. This all these issues are for more of my heart also being in the university. So the the topic here at this particular that ramifications of law and justice in the Indian knowledge system. So primarily my topic, not from I have learned a lot of Dharma Shastra and other things since morning. So my topic is not primarily based here in that, but I'm going to talk about the changes which university is witnessing in today's time in contemporary time, and the tension that that has resulted out of new liberal policies and the university, the liberal university, which is undergoing. So that tension that due to the privatization or the neoliberal manifestation, which has resulted into the privatization and further, corporatization of education, which is making the education as a very more commodified area. So that tension which we are witnessing in today's time, and that has ramifications probably in the in the epistemic accessibility to the certain domain of knowledge. Particularly if we see that the way neoliberal policies have its huge deep impact on the changing character of particularly the liberal universities which we are facing. And all of us know that post-independent India, the government of India, the way it has given significance, the way it has attached significance to the higher education, and particularly to the university education, liberal university education. And it is in that context we see the coming of the JNU and very important significance attached to various universities across India. So in that context, we see that Hyderabad University and other. So besides that, the initial focus which was there on the economic development, as we had inherited a economy from the Britishers, so definitely that emphasis was there. But besides that economic development and the way public sector model was under the mixed economy model was led during the Indian model, what already we know the Indian model of development. And in that particular model of development, the being public universities were conceptualized and post-independent India, the constitutional values in terms of socialism and as a part of the welfare state. So that the way it was conceptualized and the university, the idea of university, modern university was conceptualized. So to not just for the economic enhancement, but also to counter, to critic, to that intellectual pursuit which can, inquire, which can go deep down and inquire those certain prejudices, traditional belief systems, and all of that. So what is happening in the present time? So just I'd like to find out that tension that how it is undergoing change, how the character of the different university is undergoing change. So that when we see, I mean, post 1970s, 80s, uh, uh, onwards, we are seeing that the privatization of education is happening and gradual withdrawal of the state funding.
to the higher education particularly. So even the school education, we know that right to education was made right a reality very very late in India. So definitely higher education was given previous importance, but seeing higher education also how post this liberalization phase, neoliberal phase, how in fact university education or higher education particularly. So primarily two features, there are many others, but two features I'm highlighting here. One is that the way state withdrawal started to happen 70s, 80s, and technical education was given importance. But it is in this context when we see that 1970s and 80s, that Margaret Thatcher and Ronald Reagan in Britain and the United States of America, the way they came up with the policies, and that had its impact as a part of the structural adjustment program in the forms of the in different parts of the world, and India was one of them. So basically, what is that new about neoliberalism? When we talk about neo about neoliberalism, so new about neoliberalism lies in the idea of reviving the earlier versions of economic liberalism and liberalism under the condition of shrinking profit by corporate elites. So for them, because here, that Margaret Thatcher was that the famous dictum that there is no alternative. So under that particular pretext, the way it was highlighted that this whole under, you know, yes, so I was just pointing out that the neo or about neoliberalism, so that Thatcher was with the view of not only to transform the economy, but so the just, but it was a part of the larger political economic agenda of neoliberalism was competition, and competition not just between the nations, but regions, firms, and about everything. So in this market determined agenda, that self in society, how self was again conceptualized. So people are expected to develop useful skills or market relevant skills. So it is in this context the debate which I wanted to bring out through the Dixon model, who talks about mode one and mode two types of knowledge. So under the mode one types of knowledge, which he is highlighting that the knowledge which are now applied in the immediate context, the knowledge which is relevant in today's time, the knowledge which is useful in the immediate context. So those knowledge are being highlighted. So under that context, the one type of knowledge which was more emancipatory, which was more in tune with the Enlightenment models of bringing structural reforms and bringing people into out of certain structural tensions. So those those epistemological foundational knowledge, those based on the Enlightenment models. So here, in the heart of this modern university, and the tension between neoliberal and the public welfarist policy of public university, the tension that basically I'm trying to highlight versus the corporate power versus the intellectual inquiry, as well as between the instrumental knowledge production versus open-ended inquiry. So the question here is that this under the knowledge production, now under the neoliberal framework, the kind of knowledge production which is being done, which is being done by the university, so that is actually posing limitations. That is posing limitations on the intellectual inquiry, on the in the freedom of the university campuses to pursue, that raises questions that on those issues, like we are talking about the gender issues, we are talking about the caste issues, we are talking about various other structural issues which are still embedded, and in everyday life, the kind of and we have also witnessed the way in Hyderabad University, Rohit Damla case, so either or gradually we are seeing that the way media is functioning, democracy index is declining and all that. But in today's time, the way university is functioning, public universities is functioning in terms of not just declining the funding and the kind of research topics which are being more turned towards what actually appeals to the certain corporate people or even in the management or the, I mean, yesterday only I saw that in Delhi University, Cow Welfare Summit, that academic conference is being done on the Cow Welfare Summit and not any other. So, you just see the kind of research which has sifted, within the academic circles. So, there are many things I wanted to share, but this is not like just I wanted to point out that the way university is being set in neoliberal, not just, and the way university is being idealized in terms of certain kind of ideology. So at university, rather than becoming the source for the pursuit of knowledge, free inquiry, it is more becoming a kind of, based on the idea of nationalism, nationalistic agenda, a certain kind of, this situation of this certain kind of ideological embeddedness. In that condition, you don't get that space, that academic freedom, to shape up your curriculum, your the kind of conferences you want to do, the free inquiry which is known for, the intellectual pursuit which is known for the university idea. So that is under threat. And it's more in both ways, the under the ideology of nationalism and at the same time, and under the neoliberal paradigm where the corporate elites, so that unholy alliance between the state as well as the corporates. So that has started to dictate in the university. So basically my final submission is that the task of the university for the long-term knowledge production, for the knowledge production which is required for the students to have some kind of epistemic accessibility, where you see not just the practical intent knowledge, but abstract knowledge, in terms of the foundational, fundamental body of knowledge. So that those are being undermined. So if we don't have those foundational epistemic accessibility to the students, so some are teachers as well, so whole community of scholars. So in that context, what is happening that definitely that first of all we don't have that epistemic accessibility. We are losing that. Second, that we are unable to have that academic freedom to inquire what the larger deeper issue society is our nation is facing. So it is in this context that my submission is that the very ideal of university or the public character of the university is being undermined and may have a huge impact or ramifications for the overall social justice system as well and the development of the society and nation. Thank you. Thanks.
Thank you, everyone. I apologize if we perpetrated some mild gender injustice in terms of the length of the presentations for the women on the panel. But in any case, I hope you enjoyed the talks today. Thank you everyone for their presentation.
Now, I want to open the floor for any questions. Do you have any question, any inquiries? We have also a person here as well as I think six very distinct speakers here. Do you have any questions? Yeah. I guess we are all in a hurry right now. For the lunch, yeah. Not a question, just an observation. Just I one source was definitely written that historical culture and the particular historical culture, and it really we have to understand that reflects. My question is that when it says that that women regarding that and it has different interpretations. But my point is, observation is that at any historical period of time, whether any context, but sense of equality is getting reflected in that. Because questions is being raised time again. That whether any historical period, whether any context, even today, like we talk about Taliban, we talk about
what Israel is doing in Gaza and in different parts of the world. But I think the question comes that, where does equality prevails? You have to take action by keeping certain foundational, certain extreme, like equality in the mind. When do you frame the norm? So some iron pastoral is missing.
First of all, I don't know what to say because I am not a lawyer of none, definitely. And your observation is correct. There's a lot of papers that in which time when Manu actually write this paper, I mean this quote, the declination of Moria, and when Brahminic culture has no patronization during the time of Kushana. At that time, it was structured for, and the system of Mimamsha philosophy. According to Mimamsha philosophy, you need to act according to the scripture. So for that reason, if you are a sacrificer and you have to be a blue blue blood, and for uh, retaining that blue blood, you have to maintain the scriptural sanction through pure marriage or something else. Actually, these codes are only for the uh, IFP classes. Actually, I don't know if I should uh, use the word IFP class. Actually, it's a code from the American code, not for all. And for them, it was that. And I'm not his lawyer, but it is a problem. But we have to keep it asking. I don't know I have provided the right answer or not, but your observation is absolutely right. I don't know if you wish to add something.
So I think if you're looking for equality in the modern sense, you should not look in the laws of mind. As simple as that. So some kind of balance, the type of paper that Sir Bandapati was presenting is is, is a careful reading of Vedapati, who is uh, trying to give a different take on something. And we can certainly discuss more about Vedapati's understanding of the verse, but even Vedapati is not presenting a vision of equality.
Uh, since the crime is common, is increasing day by day in every part of India, and definitely when we see into history, we observe that there's long bias, and the scriptures just reflect us what it was. It's not what we imbibe in the contemporary world. Thank you so much, speakers and our chairperson, for conducting this session. We will now resume at 2:30 for our next technical session. And meanwhile, you can enjoy your lunch. For the on-site participants and paper presenters, you will have your lunch at the room opposite, uh, at the ICT room. And for the dignitaries, you're welcome to, I think, they take you to the right receiver. So, because our college supplement, you get your lunch and FF2.
I'm sorry.
No, no, but
Right, quite nice. So it's well done and next one. I know, yeah.
আমি দেখো আমি তাহলে ওখানে
Yeah. She did a PhD with
on several universities of India and abroad. She has authored several monographs and about 50 research articles in English, Bengali, Sanskrit, German languages on subjects like Sanskrit grammar, Sanskrit Kavya, Panini Vyakarana, Manu scriptology, Indian paleography, Indian Dharma Shastra, Buddhist literature, Tibetan translation of Sanskrit works, etc. Critically edited a rare Sanskrit commentary on Sanskrit Mahabharata, a rare text of Advaita Vedanta, a rare text of Dharma Shastra, including translating several Sanskrit poetic works in Bengali. I welcome you, ma'am, to chair this session. Dr. Ajit Mondor is the speaker for this session. He is currently working as an assistant professor at the Department of Education, West Bengal State University, Maharashtra, West Bengal. He has published more than 35 papers in peer-reviewed journal, authored 5 books, 15 book chapters, and edited 15 books on different aspects of education. This research paper, book art chapters have been featured in the journals of Sage, Routledge, Springer, Kurukshetra, Yojana, NCRT journals, and several esteemed journals. His research interests and publications are focused on policymaking and historical development of education in India, contemporary issues and trends in education, child rights, and right to education. We have with us our second speaker, Professor Ananga Vishwas Joshi. She's a professor in the Department of Sanskrit and Prakrit. It is a center of advanced study in Sanskrit at the Savitri Bhai Phule, Pune University. Honored with the prestigious Pandit's Satavekar Puraskar in 2016, recognizing outstanding contributions and excellence in the field of Sanskrit scholarship. She has served as a member of the expert committee for artwork at the Supreme Court premises, New Delhi. She has been appointed as a non-official member of the Board of Governors at the Central Institute of Higher Tibetan Studies in 2024, Sarnath Varanasi, as nominated by the Government of India. We welcome you, Vanya. We have another very distinguished speaker, Professor Diditi Vishwas. I think she is the senior most among all the speakers. She has served as a professor and head of the Department of Sanskrit at the University of Calcutta. She has served as a full-time lecturer, first at the Dawa College and then at Rambam College, Kolkata. She was awarded Ishan Scholarship for Excellence in Research. So, sorry. Professor Vishwas is associated with Ramindra University as a guest faculty in the Department of Instrumental Music. No, I can't know what to do.
Someone.
Good afternoon, everybody. Hello. Vidya Sangarayo, Gyana Sangarayo, Pandita Prabharayo, Shri Shri Ishwaro Chandarayo. Actually, extremely thankful to organize of this background seminar on the subject of another one. Ramifications of law and justice in the Indian knowledge system. Like 3 different departments
of the knowledge, directly transplant, political science, and education. This is a very good initiative to begin with such discussions. Now, as the names have been announced, I take the kind permission of the organizers and the August audience to make the to call the speakers in the reverse order according to seniority. Chief Tom Pramila, then First Professor P.T. Vishwas. My colleague wants to present Good afternoon. Respected Chair, my two co-speakers on the stage and the audience before me, I take this opportunity to express my thanks to the organizing committee of this college for giving me a chance to deliver the lecture, to share my views with you in this 2 days international seminar. The topic, the title of my topic is Evidence of Property Right in Vedic Texts, an investigation and exploration of a liberal tradition. Hindu law is one of the oldest legal systems in the world and traces its roots in the Vedas. The Vedas are considered the source of dharma, which governs human behavior. Veda Dharma Mula. The sages of the Vedic period derived the concept of disciplined society from observing the cosmic order. The governance of the natural nature inspired them to envision a proper organized human society. Smriti is an interpretation or explanation of the Vedas of Shruti. It guides what a person should do in the society. The nature of Shruti and Smriti is quite different. Shruti is religious in nature and generally provides advice related to an individual's spiritual and religious duties. Smriti texts, on the other hand, focus mainly on a person's social duties and responsibilities. Hindu personal law originates directly from the Smriti, which itself is based on the Shruti text, the ultimate source of dharma. The dharma or righteousness formed the foundation of Hindu law. During the Vedic age, the law was not codified and existed in its speech form. However, people clearly understood their respective duties, which were mainly religious or ritual centric, and any deviation from them was considered as a sin, and they had to perform expiatory rites as punishment. Despite the religious character, Vedic texts also reflect some social aspects. In this discussion, we will explore some instances where the prevailing customs of inheritance have been mentioned. I have taken some stories from Vedas, mainly from Brahmanas and Purishas, and I shall comment. The I should express my observation on this. The decision taken in this in the stories. Uttara Brahmana records the story of Naganidisha. This very long story. The son of Monu, Naganidisha was the son of Monu. The story, in brief, the story runs as follows. Naganidisha was away from home for study in his Guru Griho. And in his absence, his brothers persuaded their father to divide the property among them. And when Naganidisha to return home after study, he asked his brothers about his share. They referred Monu as the authority and of rules and criteria of property division. Ramadedisha then approached his father
Ramanatishwar then approached his father, who, being left with nothing, advised his father, his son, to acquire wealth by other means. He told him to visit the Ongirashas who were performing the sacrifice to attain the world of heaven. On the sixth day of their sacrifice, they make some mistakes and repeatedly and they are unable to complete the sacrifice. Who instructed Ramanatishwar to make them recite two hymns to complete the sacrifice and assuring him that Ongirashas would reward him with great wealth. Ramanatishwar followed his father's advice and ultimately he acquired immense riches. The story reveals that the law of inheritance was not properly established at the time. Ramanatishwar was neither dead nor lost nor a criminal, thus in no way disqualified for receiving a share of his paternal property. The narrative also shows that his father remained affectionate towards him. Therefore, the act of the other sons appropriating the paternal estate in his absence was unjust and would be considered as a punishable offense from the ethical aspect. According to tradition, sons were the natural heirs to ancestral property after the father's death, unless they directed otherwise. However, in this instance, the father appears to have been overpowered and deprived of authority, resulting in the wrongful confiscation of the property and exclusion of it with coercion. Once property was divided, it could not be reallocated for redistribution. In contemporary India, the son has no automatic right to claim a share in his father's property while the father is alive, particularly in case of in the father's self-acquired property. However, his son can exercise his supervisory right over the ancestral property during his father's lifetime, but he would have to fight a partition suit. And of course, he will have to prove his rightful succession. Such legal mechanism, however, is absent in the period of Vaidya Brahmana, and the lack of structured system of governance contributed to the injustice suffered by Nathanegishtu and Scott. Here's just another story. It is also from Vaidya Brahmana. It is the story of Shunoshepa. Shunoshepa was a Brahmin boy who was brought to Purishandra's sacrificial ground as a victim to be offered in the to Guru, as a victim to be offered to Guru. Ajimartu, his father, sold Shiva to Rohidashram for this purpose. Abhishamitra was the chief priest of the sacrifice. Shurashiva was hopeful that this way or by that way he will be able to be released from this sacrificial ritual. But when he was tied with the trooper, he became desperate and he fervently prayed to the gods, various gods, for liberation. Through this prayers, he attained the status of a rishi and ultimately was unfettered by Guru. Being released, Shurashiva prayed to Vishwamitra. Vishwamitra accepted him as his son, considering him as a gift of God, and renamed him Devarata. Devarata means gift of God. Shurashiva was included in Vishwamitra's family and was granted the right to property of this sage. Vishwamitra instructed his 100 sons to regard Devarata as the eldest child. The first 50 sons refused to obey Vishwamitra and were consequently disowned and cursed by their father and born as outcasts. The remaining sons complied, and Vishwamitra promised them his material wealth as spiritual body, of course, shared equally with Devarata. In this episode, Shiva or Devarata can be regarded as the adopted son of Vishwamitra. Under modern Hindu law, there is no distinction between a natural born son and an adopted son. both enjoy equal rights to the ancestral and self-acquired property of the adoptive father. Vishwamitra, though having biological sons, acknowledged the characteristics in this and conferred upon him both material and spiritual dignitaries. The Uttara Brahmana states that Shunashipu was granted the wealth Ritka of both lineages, the Janus and the Nathis. His father belonged to Janu lineage and Vishwamitra belonged to Nathis lineage. He inherited the power of dominance from the former, from the Janus, and sacred growth from the Nathis. The contrast, however, is evident when compared with Manu. He denies the right of adopted to the gotu and property of his biological father. Gotu dicte janayetu non varit tantrima pachi. Putra dictanu pinda papaiti dadata spatha. According to the modern law, under the Hindu Adoption and Witness Act 1956, the adopted child's rights and liabilities are completely severed from the natural family. Thus, an adopted son has no claim to property of his biological father and or his family. In reality, the word ricto here in this operation does not refer to material wealth, because it was restricted. The 2 years applies exclusive academic and spiritual inheritance is never denied. Material wealth is denied, but the academic or spiritual wealth has not been denied. So, Shiva or Devoratu, he inherited the qualitative part of the two lineage. Moreover, it must be acknowledged that the emotional behavioral influences of one's own biological family can never be completely erased. But it is interesting to note that Sarana underlines rulership as a Damushai. Damushai, according to the latest treaty text, belongs to two gotras and two families. And he is eligible to inherit the wealth of two families. The question is whether Shurashipu is at all called Damushai. According to Jagavatu's treaty, there was a childless father. If a childless father gives the sons in others' wife, child born is called Damushai. Putrenu or Putrenu Nigot Paditu Sutta, Hoyoroku Kasan Nikta, Nikti Lata Jakarmata. He inherits the gotra and property of the biological father and that point. Shunashipu by no way falls under its statute. So Shaila's condition is not clear. However, this incident is recorded in the Vedic text in the Brahmana, indicate that certain customs or principles existed in accordance with the conditions and rules of the Vedic society. These practices later inspired the lawmakers to reformulate them into formal laws, defining their scope and application and rectifying the loopholes evident in the earlier traditions whenever necessary. Let us now examine a few cases concerning women's right to property and prevailing social attitude at the time. The Hindu law of inheritance has been factual in nature since the Vedic period. The idea of women holding property was in general rejected by the early lawmakers. Women could however possess gifts received from relatives and friends as sridhana, which constituted their personal property. Thus, in the Vedic age, women's right to property was limited. After a man's death, his sons were regarded as the natural inheritance of his state. The widow or widows and unmarried daughters were entitled only to maintenance by the sons until their death. In this environment, which was largely unfavorable to women, we find in the Vedic text that Jacoba took that exceptional state. This is the third business. Jacoba, before renouncing worldly life, Pravarja, he decided to divide his property between his two wives, Maitri and Tatal. This was not a case of intelligence. This was a deed of gift. Pravrata implies total denunciation of material attachments and entry into the Shastra. In order to ensure the financial security and well-being of his wives in his absence, Chakravarti arranged to bestow property upon him. The decision raises some questions. If Chakravarti's sons were his natural heirs, they could have taken care of their mothers. Then so why should he divide their property between his two wives? We can infer that we can infer that Jagbal was either childless or lacked sons or did not trust his son to support their mothers or deliberately intended to deprive them of inheritance for some personal reason. This, however, remained by hypothetical conjectures as to lack concrete evidence regarding Jagbal. Nevertheless, Jagbal action was unusual for this time. And it demonstrates that unlike many contemporaries, he did not focus the idea of women owning wealth and property. The gradual decline in the position of women became evident in the later period. The Dharmasutras did not recognize the wives and widows' right to her deceased husband property. They acknowledged only the legitimate sons as rightful inheritors when the father died intestate. In absence of a son, the property was transferred to those related to birth, like blood, sucking, and belonging to same Sagam. Interestingly, we find in the writings of Dashkar, the author of Nirukta Vedanga of approximately 700 BCE, the certain arguments in favor of the women and their right to property. Dashkar, in his analysis of the word Apatya, offers two etymologies. Avatatam bhavati, nanena pat. Avatatam bhavati means one who speaks the lineage being separated from the father. And nanena patati means one through whom the father does not fall into hell. According to these regulations, the offspring continues the father's lineage and saves him from falling into hell by performing pinga according to ancestors. Etymologically, the word Apatya thus includes both the son and daughter, as both are capable of continuing the family line. However, in patriarchal society of the time, the male child was considered more treasured. In this connection, Yaska quotes the opinion of Odin, the son of Swan, who at the very beginning of creation declared that the right to paternal inheritance belongs to all children without any discrimination. Abhisheshara Putranam Tayo Bhavati Parmata, Mithunanam Visargadu, Sadu. However, a contrary opinion also prevails in the society, one that denied daughters any right to paternal property. As they are said away, but not the sons, because boys are sent away to a different family, to a different place by through marriage. But after marriage, the sons remain within the family. They are not liable to go to another place. That's not woman and that is the special quality for the inheritance of the paternal property. Woman Dayado or Dayado stream. Tasmat Striyam Jatam Parakshante now mouse. Therefore, daughters are sent away, but not the sons. Because Parakshante implies the girl is a gift marriage sent to another person, meaning they're married. The statement has been used to justify the notion that only sons are eligible heirs of ancestor property. Further arguments supporting this bill. Srinam Dano Vikrayo Kutisarga Vidante no Pusa. Daughters may be given away, sold, and abandoned, but not the sons. What does it mean that Dano Vikrayo Kutisarga? Dano means giving away a daughter in the down form of marriage. Vikrayo means selling her in ugly form of marriage. Kutisarga means abandoning her in the swan murder when a maiden chose her husband from the assembled suitors. However, this argument was refuted by Indian. Probably Dashkar himself has refuted it. And he was taking this as baseless. Because even more children
Because even male children were on occasion sold or abandoned. For instance, we have found just come across the story of Shurashiko was sold by his father and was abandoned in the sacrificial ground to die. So this reasoning cannot justify the exclusion of doctors from that job. Jasper also cites another opinion. Another opinion in this through this debate, which allow daughters to inherit their father's property in some special cases. What is the special case? If the daughter has no brother, then he could inherit the property. According to this interpretation, the verse social could be discussed. Dashko has, at least the point, Dashko has quoted a verse from the Veda, which actually shows the. It is very interesting to know that in the represent. That it was very interesting to know that the Vedic verses were very arcane, and their language were very difficult to understand the meaning of that meaning to get the thing. The, the, the same verse can be interpreted in different ways. During Jashko, the time of Jashko noted that the first social bonding, etc., has been integrated into different groups. One in support of the daughter's inheritance, and others in support of the son's inheritance. And so, slave, now he wants to interpret the same verse in another way. That is American it is explained here that a daughter can inherit his father's family if he has no brother. This the father it's this daughter in marriage. He promises that the son who will born through his daughter, will be considered as his grandson from his father, from his son. So Potra and Pavitra go being the same. So there is no difference between the Pulitri and Putra, and they being they're eligible, the daughter is eligible like the Putra to inherit the property. This is the another interpretation. The same Mudra, and this is we often found that the commentators differ in the explanation of the meaning of the mudras, and this is found in 700 BC. This is found in the 700 BC by Yash. So the difference of meanings have taken place at the very antiquity. It should be known. And the commentators took very all opportunity to explain the mantras in their own way. And this is noted as noted by Yashko in
Sound performance
This is-
fire.
yeah, the good he quotes Tashko cites this allow daughters to inherit their father's property in the absence of guardians. According to this interpretation, the Vedic verse discussed earlier clarifies that if brotherless daughter may exercise the right to father's estate. In such a case, the father symbolically declares the daughter as a son and accept the child born of her as a grandson, Putrika Putra, as though born from his own son. Putrika Putra was considered a member of the mother's
family. And the religious beliefs, Pindodanu, Shraddha, etc., performed by him, occurred to his patriarchal ancestors. Although it not explicitly stated in the earlier sources, later texts confirm that Putrika always belonged to her father's lineage and her husband would not take her into her own family. So Rajput father quotes another mantra to show the son's son's inheritance to paternal property. He quotes another mantra from Rigveda, no Java, Tanva, etc., which asserts that a brother does not transmit his inheritance to his sister. Brothers also does not allow the sisters to take their share of the paternal property. He gives her away in marriage. When a man had both sons and daughters, the sons performed father's funeral rites. When the daughter received gifts and ornaments or garments, and the daughter was not recognized as the heir. The son was the only eligible person to inherit the property. However, the preference for the son's exclusive right to inheritance likely arose from a practical consideration to prevent the division or transfer of ancestral property to another family through marriage. It might be the reason why they did not like to share the property with the in-laws, families of in-laws of their daughters. It is however evident wives were recognized as partners in their husband's religious and spiritual duties, but not as legal heirs to their property. This may explain why Jacobanco felt the need to give his property in equal shares to his wives. Otherwise, they could not have legally claimed to ownership after his renunciation. If Jacobanco did not divide the wealth to his two wives, they could have no claim to their husband's property. Jacobanco then renounced legal authority. It is significant to note that Jacobanco then renounced legal authority explicitly acknowledged a wife's right to inherit her husband's property. He declared the wife is entitled to an equal share with the sons, provided she does not already possess separate stream sons given by her husband or father-in-law. He also prescribed that if a man dies sonless, his property should pass first to his wife and in his absence to his daughter. Later, Vikarnishanu in his Vidakshara specified that a wife possessing Srihanna would visit half of her usual share. Timotbagna's dialogue father recognized the wife's right to share in her husband's property along with the sons after his death. The text also records an alternative view prohibiting partition during the lifetime of a freedom mother. It grants an unmarried daughter one-fourth of her father's property. If the estate was too small, each son could divide his portion equally and give one-fourth of his share to his sister. Although Jacobanco of the Upanishad and Jacobanco of the Smriti are likely not the same person, it is remarkable that both advocated for women's right to property, either of the father or of the husband. Putila, however, maintained a conservative view, declaring Bhogina or Ayada. Sisters are not heirs. From this discussion, it becomes evident that the principles of inheritance were not fixed during the early period. Over time, as social attitudes evolved, these customs were revised and codified. Takubaku stands out as the first spiritual authority to unambiguously recognize women's share in property, recording his view in that environment. Yet, I think his position did not emerge in isolation. Although most lawmakers opposed women's inheritance, there always existed a line of liberty thought since ancient times, where the opinions of these early reformers are not fully preserved. Their influence is traceable through secondary evidences. Principal Suti Mullah in Sriti applies aptly here. The Atik Sruti texts are interpreted diversely by the commentators and noted and recorded by Yashka Santi. He presented both sides of the debate, but according equal rights of sons and daughters, the other denying them. Yafko likely borrowed this argument from existing traditions for dialectic conflicts. Later, Jacobi systematized and codified these ideas, which gradually matured into legal reform. Finally, it was in 1956, with the enactment of the Hindu Succession Act and its 2005 amendment, the gender equality in inheritance was formally established in Indian law, granting sons and daughters equal rights to ancestral property. Thus, the long evolution of inheritance law from Vedic customs to modern legislation demonstrate the enduring presence of reformist thought within Indian tradition. We can indeed take pride in those early thinkers who refused to follow precedent blindly, applied that refined understanding to reform and humanize the law in keeping with the spirit of the law. Thank you.
Thank you, Professor Vishwas. Special thanks for completing it within stipulated time. Now we have experienced how efficiently Professor Vishwas tackled the very difficult subject matter of law of inheritance, how starting from the Vedic period and up to bringing it to the ramifications of the current Indian position of inheritance rights to parental property or husband's property, including the right to inherit father's property or even mother's property of the amount of children, both male and female, how it worked at both times and what the wishes thought, and how these have been through the ages, time and again, discussed and debated upon, from Jasper to the commentators of Yakovalpasmriti and so on. And she brought the things up to the current situation and current sensibility. Thank you very much, Professor Vishwas. I'm proud to announce that she has been my guest, my colleague in the English Calcutta. Now, may I request Professor Anotha Vishwas to enlighten us with the presentation.
Good afternoon. Namaste Sharade Devi Saraswati Matiprade Vasatvam Mama Jibhagre Sarva Vidya Pradabhu. Respected Chair Professor Ratnavasu and my two co-speakers. Today, the title of my paper is Law and Justice in the Indian Knowledge System, Insights from Smriti Literature. It is truly a privilege for me to be among such esteemed faculties and scholars gathered here today. Before I share my thoughts on law and justice in the Bharatiya Jnana Parampara, insights from Smriti literature, I would like to express my gratitude to Professor Sundapa Ray, Principal Vidyasagar College for Women, and her dedicated team for giving me the opportunity to be a part of this program. I also extend my sincere thanks to convener Dr. Piyali Vishwas for her efforts and support. The new education policy has begun to bridge the gaps between disciplines by promoting a multidisciplinary approach and encouraging the integration of traditional knowledge systems with modern education and research. The NEP has opened avenues to Sanskrit scholars. Indian Knowledge Systems Division under the Ministry of Education, Government of India is dedicated to the promotion of India's rich and diverse intellectual tradition. Indian knowledge system, that is Bharatiya Jnana Parampara, rooted in the ancient Indian wisdom and philosophy, spans a wide spectrum of disciplines, including philosophy, mathematics, literature, law, commerce, governance, as elaborated in the Kautilya Arthashastra. Sanskrit, being a classical language, is rich in its contents. It is the storehouse of ancient wisdom inherited from sages, philosophers, and thinkers. The legal tradition of India was recorded in the Sanskrit texts, namely Dharmashastra. Dharmashastra texts occupy a prominent place in Sanskrit literature, and it pervades various aspects of Indian social and cultural life and attempted to bring discipline in individual and social life in terms of values in which they believed in those days. Some values are universal, while some others kept on changing in course of time. The compound expression Dharma Shastra is formed of the two words, namely Dharma and Shastra. Dharma is one of the most complex expressions which cannot be defined or explained precisely. Etymologically, it is derived from the root dhru dharayati, which means to hold, to bind, to sustain, to support, to preserve, etc. The concept has occupied the central place in ancient thought. It refers to the right or proper conduct, and it covers English concepts such as ordinance, law, usage, customary observance, morality, duty, obligation, religion, attribute, and quality. It is rightly stated in the Mahabharata as Dharana Dharmam iti abuhu, Dharmo dharayate prajaha, yasyat dharana sanyuktaha, saha dharmaha iti nishchayaha. Dharma, derived from dharana, signifies its fundamental nature of support and sustenance. It upholds society at large, providing stability and order. Therefore, dharma is that which embodies dharana, the essence of preservation and righteousness. And last but not the least, there is one more important aspect also. The well-known rule that every right has a correlative duty is embodied in the word dharma, which is indicative both of right and duty. Dharma Shastra is known as Smriti, and it is stated in the Manusmriti as Shrutis tu Vedo Vidnyeyo Dharma Shastram tu Vaismriti. Shruti literally means that which is heard, and Smriti that which is remembered. Shrutim Pashyanti Munayaha Smaranti cha Tatha Smritim. The Smriti literature contains comprehensive rules for the governance of the society as a whole, and they were not confined to purely religious matters. The Smritis did not declare for the first time what the rituals and domestic duties were, but only repeated what was being followed by the people traditionally through ages. Dharma Shastra may be understood as a record of customs from various parts of India, and the difference in the Smritis was due to the different local customs. These Smritis were not laws made by Parliament, but Medhatithi, in his commentary on the Manusmriti, opines as Smritis were codifications of the existing customs. Here, hence, the study of Smriti literature becomes central to understanding the practical dimensions and conceptual dimensions of law and justice in ancient India. This paper aims to explore and analyze the various dimensions of law and justice within the Indian knowledge system with a particular focus on Smriti literature. In classical Indian thought, deviation from the path of dharma will result in the arajataka. The Indian legal tradition always stressed on dharma and righteous conduct in life. In fact, this idea will be found to be prevailing in all the Smritis also. The first verse of Narada Smriti opens as follows: Dharmaika tanaha purushaha yadasan satyavadinaha तदा न व्यवहारः अभूत् न द्वेषः नापि मत्सरः नष्टे धर्मे मनुष्याणां व्यवहारः प्रवर्तते द्रष्टा च व्यवहाराणां राजा दण्डधरस्मृतः. When people were devoted solely to dharma and lived truthfully, there was neither the need for law and justice nor the presence of hatred and jealousy. However, when dharma declined among men, the administration of law and justice became necessary. In ancient times, the king was entrusted with the role of resolving disputes and upholding justice by punishing wrongdoing. The king was the custodian of social order. The first and the foremost duty of the king is to protect his subjects. To quote, the dushtasya dandaha, sujanasya puja, न्यायेन कोशस्य च संप्रवृत्तिः अपक्षपातः अर्थीषु राष्ट्ररक्षा पंचैव यज्ञाः कथितो नृणानाम्. These are the five yajnas, that is universal duties that a king must uphold: to punish the wicked, to honor and protect the virtuous, to enrich the treasuries through just means, to remain impartial towards litigants, and to safeguard the kingdom. The Arthashastra also emphasizes that the well-being of the king is tied to the well-being of its subjects. As stated in the text, Praja Sukhe Sukham Ratnyaha, Prajanam tu Priyam Hitam, Na Atma Priyam Hitam Ratnyaha, Prajanam tu Priyam Hitam. It is clear that in the happiness of his subjects lies the king's happiness. In their welfare, his welfare. What is dear to the king is not truly beneficial, but what is dear to the subject is truly beneficial. The king is thus portrayed as the guardian of public welfare. He is described as the promulgator of laws responsible for establishing and upholding justice. The Smritis arrange their contents and treat the subjects under three principal heads, that is, Achara, code of conduct, Vyavahara, litigation or a dispute, and Prayashchitta, that is, expiations. The term Vyavahara is used in several senses, such as transaction, a dispute, or a litigation, legal procedure, or judicial proceedings. The concept is used as a device to settle disputes and to uphold cosmic order. Legal matters are discussed under the name Vyavahara in the Smriti literature. Smritikaras have been ascribed the various aspects of Vyavahara, and it is from this aspect Vyavahara is Genesis as vi nanarthe ava sandehe haranam hara uchyate nana sandeha haranat vyavaharaha iti smrutaha. So the term Vyavahara is derived from its root components. V meaning various, ava signifying doubt, and hara meanings removal. Thus, Vyavahara refers to that which dispels various doubts, ensuring clarity and resolution in disputes. The earlier texts on Dharma Shastra were not very explicit about law in general and legal procedure in particular. About legal procedure, it is stated in the Bruhaspati Smriti as Dvipadaha Vyavaharaha Syad Dhana Himsa Samudbhavaha द्विसप्तकः अर्थमूलस्तु हिंसामूलश्चतुर्विधः पदानि अष्टादशैतानि धर्मशास्त्रोदितानि च. It means lawsuits are divided into two groups. Disputes arising from wealth are categorized into 14 titles, and while those arising from harm or injury to living beings are classified into four titles. Bruhaspati, one of the prominent ancient lawgivers, Smritikara, was probably the first jurist to make a distinction between civil and criminal law. Though this division does not exactly correspond to the division of law into civil and criminal, but we may say that the category of Arthamula, that is, as the result of Lobha, and that of Himsamula, to be result of Krodha or enmity or anger. In all, there are 18 titles of law or grounds for litigation, which has been accepted by all Smrutikaras. But the classification into 18 titles is not also a restrictive provision. Narada and later Smrutikaras expressly stated that subheads of conceivable legal disputes could be innumerable. Among these 18 titles of law or grounds for litigation, Sambhuya Samuthana is one of the grounds for litigation in India. Sambhuya Samuthana is a compound word, Sambhuya and Samuthana being its two constituents. The word Sambhuya between these two is derived from Samabhu, and the other constituent, namely Samuthana, is derived from Sama Udastha. The word Sambhuya, which is Yavanta form, means being together, being united, or combined with. And Samuthana means the act of rising up, getting up in common enterprise or partnership. And so this compound word, namely Sambhuya Samuthana, means rising up by coming together. Narada, in the Narada Smriti, has given the definition of Sambhuya Samuthana. Manik Prabhutaya Yatra Karma Sambhuya Kurvate Tat Sambhuya Samuthanam Vyavahara Padam Smrutam. When traders, merchants, priests, actors, artisans, etc., work together or start business or undertaking jointly with labor, capital, or both, then that is called as Sambhuya Samutthana. The word Sambhuya in this verse is interpreted by different commentators differently. Some say Sambhuya Ekatra Militva, whereas some paraphrase as Sambhuya Dhanamelakam Krutva and explains the word Samuthana as Samupatishtante Ruddhim Prapnuvanti iti Samuthanam. Smriti Chandrika opines as Vanijo Vanicham, Rutvijo Yajnam, Krushivalah Krushim, Hemakaradayah Shilpam, Nartakadayah Nruttadikam, Yatra Samhatya Kurvate, Tat Sambhuya Samuthanakhyam Vyavaharapadam Ityartha. When merchants do merchandise, priests perform sacrifice, farmers do farming, artisans prepare crafts, actors perform acting or dancing by coming together. That collective work is known as Sambhuya Samutthana, as literally it means by this collective effort, they prosper collectively. Mimamsa, which is one of the orthodox systems of Indian philosophy, may be understood as Indian hermeneutics. As per the Oxford Dictionary, the word hermeneutics stands for the branch of knowledge concerned with interpretation. The term Mimamsa here stands for Purva Mimamsa, and it concerns itself primarily with the interpretation of the Vedas. It is known as the science of sentence interpretation for the same purpose. The Veda was the basis of the ritual culture prevalent in the then society. Purva Mimamsa interprets the sentences in the context of the performance of various Vedic rituals. The laws of interpretation formulated by Jaimini are applicable to Vedic sentences. However, in course of time, they were utilized particularly for interpreting the Smriti texts, that is, legal treatises. These rules play a very important role regarding the Smriti literature in general and texts on Vyavahara in particular. For example, Jaimini has discussed an important topic about Dakshina, that is sacrificial fees, in the 10th chapter. It is established that Dakshina is to be given for engaging the priests to perform rites required in sacrifices. In the third pada of the 10th chapter, it is stated as at the Jyotishnoma sacrifice, the cow is to be given as the fee because the cow is most useful. The prima facie view is that is Purva Paksha, there should be an equal distribution of the fees as Shruti does not lay down any unequal distribution. In Jaimini's Purva Mimamsa Sutra, it is rightly stated that samam syad ashrutvatvat. But the Siddhantis rejected the view and established that the fee should be distributed in proportion to the work done by the priests. The diversity in the fees received by the priests should be regarded as based upon these titles, namely Ardhinaha, Trutinaha, Padinaha. In the Purva Mimamsa Sutra or Manusmriti, the discussion is in the context of sacrifice. From this point of view, there is a distribution of the share according to the work done by them and not from the capital invested by the member. But when we come to Yajnavalkya and later Smritikaras like Narada and Bruhaspati, we find that they have discussed the concept of Sambhuya Samuthana not only in the context of sacrifice, but also in the context of business. Yajnavalkya has clearly stated that these principles followed by the priests as well as artisans, as they all work in joint undertaking. To quote from Yajnavalkya, Samavanyena Vanija, Labhatham Karma Kurvatam, Labhanabhena Yatha Dravyam, Yatha Va Samvida Krutam. So, when multiple traders, merchants, or professionals, such as actors and artisans, unite to conduct a trade or enterprise for profit, they shall distribute the profit or bear the loss in proportion to their respective shares or as stipulated in their mutual agreement. It is a general rule for any cooperative enterprise. 5 minutes. 5 minutes. Then I have to skip. Then Yajnavalkya has given the Pareha. I will skip and conclude in 5 minutes. When we speak about the partners, obviously the question arises in one's mind, what are the qualities and disqualities of partners? In other words, with whom one should start a business and with whom one should not. Bruhaspati gives the list of persons who are fit to take up business with. Bruhaspati states, Kulina Dakshanarasaihi, Pradnyaihi Nanakavedhihi, Ayavyayadnyaihi Shuchibhihi, Shuraihi Kuriyat Sahakriya. One should engage in business partnership with individuals of noble lineage who are vigilant and active, intelligent, well versed in currency and financial matters, proficient in accounting and financial management, and possesses integrity and courage. It is a description of the qualities of partners, the persons with whom one should start a new business or enterprise jointly should have these qualities. The reason why Bruhaspati states this is clear. If the partners are chosen properly, then only the partnership will become successful. Then Bruhaspati states who should not be made partners. Wise persons, I skip the Sanskrit verse. Wise persons should avoid conducting business or trade with those who are weak, lazy, afflicted by illness, then lacking a capital foundation. In the commentary, Aparartha makes it clear that Ashrayo Mooladhanam. This makes it clear that foundation here stands for financial foundation. All activities of men aim at happiness and prosperity, so also partnership. Their aim is to become wealthier, that is to gain profit. And all this is quoted Yajnavalkya in only one line, namely, Labhartham Karma Kurvatam. Summary? The problem with it, 3 4 minutes, no problem. One of the another important grounds for litigation is non-payment of wages, that is Vetana Dano. Here also, Yajnavalkya has clearly stated that yo yavat kurute karma, tavat tasya tu vetanam. So wages should be proportionate to the work performed. One most important point, I will skip some point and 2, 3 points I will. In the employer-employee relationship, because this is important nowadays also. In the employer-employee relationship, the necessity to paying fair wages hold prime importance. As stated in the verse, it is from Shukraniti, na kuriyat dhrutilopam tu tatha vidambanam. Wages should be, employee should neither withhold nor delay the payment of wages or salary. Then wages should be considered as fair when they are sufficient to meet all essential needs. It is a fundamental requirement for ensuring the well-being and dignity of the employee. It is also stated that employer should accord fair and humane treatment to the employees. As stated, ye bhutyam hina bhutikaha shatravaste swayam krutaha parasya sadhakaste tu chidrakosha prajaharaha. So paying low wages can turn employees into adversaries, leading them to misappropriate or misuse of funds from treasuries and exploit the public. Low wages, harsh treatment, insults, verbal abuse, excessive fines, and severe punishments lead to unrest among employees. On the other hand, when employees receive fair wages, they are honored with promotions, treated with kindness, and supported in times of distress. They remain loyal and never abandon their master. So this is translation of the verses वाक्पारुष्यां न्यूनभृत्या स्वामी प्रबलदण्डकः कृत्यं प्रशिक्षयेत् नित्यं शत्रुत्वं तु अपमानकः धृतिदानेन सन्तुष्टा मानेन परिवर्धिताः सान्त्विका मृदुवाचार्ये न त्यजन्त्यधिकं हिते. So the above provision ensures a cordial relationship between employer and employee, which is of utmost importance for the success of any administration, industry, trade, or business. It seems that Smritigaras had a comprehensive wage policy which aimed at the protection and welfare of the community of laborers, by which the laborer welfare of the society will be achieved. So, that is it. And conclusion. Today, the world is different, and many things in the tradition may seem irrelevant in modern times, as time is changing very fast and science has advanced to a very great extent. But there are certain principles which will remain there forever and which will be tested on today's needs but will never be discarded. This is an ongoing phenomenon as interpretation is the basic need of humanity. Human nature has remained the same through ages. Hence, many of these rules are still applicable. Only the context and details may have changed. The implementation of National Education Policy 2020 will open the doors to learn Sanskrit to, to those students who have background of science, commerce, management, so on and so forth. But it would be a great opportunity as well as challenge for the Sanskrit scholar to prove the potential of Sanskrit to cater the need of students with different or other than Sanskrit background. What is needed is a genuine interest in going deep into this age-old ancient Indian knowledge system that is Bharatiya Jnana Parampara. Thank you for patient hearing. Sorry. Yes.
Thank you, Professor Umangal Joshi. Our presentation was just like that, also on a work. It was flawless and I enjoyed it and I was observing very minutely and very keenly because one of my students is doing PhD on this subject of Sambuddha Samsanga under my supervision. So I think she will benefit much from your paper. And it is extremely interesting to know that something like this cooperative or joint initiative was constrained even in the time of Vedas. So Shrutis, that were also disordered quite pertinent. At first we have lessons on Shruti from Madam Biswas, and then about Smriti from Madam Joshi. And she nicely handled. And this Samoya Santano, cooperative or Joseph business is very much pertinent for our current sensibility. So this is the historical truth for our Indian knowledge system. I can is there the conceptions are there, and I can and the matters of litigation. So and how much share one invests, and with whom one invests, the points for cautions and the precautions analyzed in the Shastras for some time is very important. And in one text of Smriti, I found a line that all these contracts for any case of Sambuya Samtano should be made in writing and with witness. And the witness also should respectively sign. And then only it becomes a document. That way, this has ramifications. We come to the history of writing in Indian knowledge system also. Now, may I request Professor Ajit Mondol to enlighten us with his presentation.
Child rights.
Child rights. Excellent.
Actually, fully not alone.
अच्छा
Just
सिर्फ पढ़ना इस चाइल्ड राइट नहीं बोल रही
yes.
है बोल
Now, English will be escolar.
problem on child rights and children's rights. Michael Vulnerable, let the story
Definitely. এটা spend একটা cognition Thank you. The cognition book sheet. ঠিক আছে ঠিক আছে Good afternoon, everyone. At the very outset, I would like to convey my thanks regards to Honorable Principal Ma'am, Dr. Shutopa Ray, Vidyasagar College for Women, and thanks definitely goes to convener of the 2 days ICSSR sponsored international seminar, Dr. Priya Biswas, and thanks to Shamba ma'am for inviting me for sharing this platform, and all the colleagues
of this college and my dear students and honorable speakers. And I would like to thanks also to Chairperson, Professor Rapna Boshu, uh, University of Calcutta, retired Professor, Department of Sanskrit, and my co-speakers. I am talking about now child rights in India, unpacking the law, the policy and practice. I'm not talking about the dharma in the Vedic period. I'm talking about the present dharma of India as a nation state in the domain of particular in the child rights. After independence in India 1947, all of you know that the first comprehensive education commission, Indian Education Commission, published in that 1966, Kothari Commission. The first line, the first sentence, the report begins with the first sentence. The children of India is now being shaped in a classroom. It is time to see, in time to examine how our classroom is going on. Most of the classrooms are now empty due to dearth of children. But all of you know the children of today are the future of tomorrow. Biologically or from the perspective of psychology, child is the span, childhood. Childhood is the span of life from birth to adolescence. Total lifespan can be divided into several segments as per is birth to 5 to 6, early childhood, late childhood, and adolescence and adulthood. But profile of child population in India at present, not only at present, but according to the last census, around 440 million. But as per the last census, India has 158.7 million children in the age group of 0 to 6. This figure is very significant. Now, who is a child? Legal, there are so many legal definitions across, not only in India, across the globe. In Indian context, if we, before going into Indian context, the very significant landmark convention, UNCRC, 1989, the first article defines the child means every human being below the age of 18 years, unless under the law applicable to the child, the majority is attained earlier. This convention categorically grants the discretion to the individual countries to determine by law whether childhood should cease at 12 or 14 or 16 or 18, whatever is they find appropriate. That's mean any country can stipulate the age of child within the definition of childhood or child. Another few definition taken from various laws in India. Number one, RTE Act, the Right of Children to Free and Compulsory Education Act 2009. This act defines child. Child is means a male or female. Child of age of 6 to 14 years. Even CRC tells about 18 years. Our Right to Education Act tells about 14 years, up to 6 to not only 0 to 14, 6 to 14. Under the child labor, already know 1996, it's also talking about 18 years.
In 14 years, not at talking about 18 years. Actually, the trouble with child rights begins with the very definition of a child by laws. There is no uniform age group about child, who is a child. There are so many, you can see, please look at the slide due to time constraint. Is right. Right is an agreement or contract established between the person who holds the right and the person or an organization which has the capability and the duty or obligation to fulfill the rights of the person. That means one receives, another provides. There is an agreement, such type of agreement. What is child rights or children's rights? UNCRC, children rights are the basically human rights. Human rights of children are called child rights. But there are minimum entitlements and freedom that should be accorded to a person before the age of 18, regardless of race, caste, creed, and any geographical stratification. Geeta Chopra, renowned child activist and writer, academician, in her book, Child Rights are those special set of privileges which apply to all humans who are younger than 18 years of age. So this is the right and child rights. But children's needs, there is a difference between children needs and rights. Actually, rights ensure the needs of the child. Needs first, then the needs, how, in what way the needs will be fulfilled? Through rights, guarantee of rights. Then, which came first? Whether human rights or child rights? Definitely, human rights came first in the domain of, in the global domain. Human rights are inherent to all human beings. These are rights which every human being is entitled to enjoy and to have protected by virtue of being born as a human being. The notion of human rights preceded the notion of child rights. But it was only during the 1970s or 1980s that the concept of child rights emerged. Actually, we have witnessed there is a shift, paradigm shift from welfare to right-based approach in the domain of child rights, in the for the protection of our children. Paradigm shift. According to Asha Bajpai, another renowned academician and writer, before 1839, there was a concept of authority and control over our children. From this condition, we have radically changed our position regarding our children, regarding the protection and their nurture and their future of our children. Due to time constraint, I just speak my view. International movements for rights of the child just first it started in the year 1919 in the year the Geneva Declaration. Declaration in 1994, League of Nations adopted the Declaration of the Rights of the Child. After Second World War, the UN Fund for Urgency for the Children was created in the year 1947. Then all of you know, Universal Universal Declaration of Human Rights 1948. Next,
we have seen 1959, even General Body Assembly adopted UN Declaration of the Rights of the Child, UNDRC. But this declaration was not implemented in full swing. There are so many parameters or safeguards embedded within the declaration, but not implemented in full swing. Later, we have seen in the year 89, Landmark Convention. It is the first comprehensive declaration, international declaration or convention about the rights of child. Adopted in the year 59, but it came into force or effect on 1993 next year. There are 54 articles in this convention. Mainly, all the articles cover economic, civil, social, and political cultural rights of child. No right remains left. Everything about child with this convention. Actually, core child rights, right to survival, right to development, right to protection and participation. The four cardinal rights about child rights. But now I talking about child rights in Indian context. Our constitution came into effect in the year 1950, 26th January. But our constitution it can be branded or labeled as a reservoir of child rights and human rights. Actually, basically, our constitution based on all the uh, human rights embedded in the Universal Declaration of Human Rights. But mainly there are four articles categorically deals with the child rights in India. First, Janagana we have got in the year 2002, Right to Education Act. After independence, two acts made in the parliament in New Delhi. One is a right to information in the year 2005. Another is RTE Act 2009. This is the best comprehensive law act after independence in India. The highly potential, highly effective for transformation of our the scenario, present scenario, the present phase of our nation in every aspect. National policies since the adoption of our independence, attainment of our independence, government of India as well as Indian government as well as state governments have formulated so many series of laws. These are national health policies such as National Charter for Children. Actually, all these acts or laws are meant it's their aim to ensure child rights. Last session, were child rights in India still at stake? We are not in position to say that our children are at good condition or regarding their own all-round development. In the words of Swami Vivekananda, education is the manifestation of perfection already in man. But our children uh, are not getting their rights. Though, despite so many constitutional rights, statutory bodies, but why it happens? There are so many reasons and factors behind our
denial of our child rights. Just I want to talk about the post UNCRC phase. Actually, from our independence, Indian government also adopted welfare approach, not only for children, but also for women. Radically, gender, gender perspective, gender equality, gender equity, social equality, the broad concept came under the banner of education. All of you know 1974 landmark report towards equality. This report showed our women folk are not in good condition due to lack of our attitude. When our second national policy, 1986, this policy categorically advocates the education only one single tool for empowering our women. Only one single. Then equal access to resource, irrespective of gender. This concept has been embedded in our national policy. So, after UNCRC, 90s decade, also India, government of India, Union government of India adopted a right-based approach towards our children. There are so many factors. Why? Right-based approach to child's education is central to child rights to development. Child's development entails right to education, right to learning, right to relax and play, right to all forms of development. So education is also a central key to unlock all the rights of our children. Basically, you can say why education is the fundamental child rights and human rights. Education is the central key to explore all the other human rights and child rights. You can utilize the education as a central key if you to explore, if you to manifest our, utilize or actualize our other rights. All of you know, 1992 government of India ratified UNCRC. Why? Basically, under pressure. There are two reasons. Number one, Article 28 of our Constitution. Article 51C. It was obliged to foster respect for international laws and treaties. Based on this, in tune with the article, the Indian government was bound to ratify. Another reason, Article 28 UNCRC, this article obliges commitment from its members nation to bring their national legislation. That's why Indian government has formulated or ratified UNCRC. Another book, landmark book, in the year published 1991. This book highlights the fact that existence of child labor. All of you know child labor exists due to poverty. Number one reason, poverty. We know. But this book highlights existence of child labor and illiteracy of the child was more so prevalent due to non-empathy of middle class and state bureaucracy than alone the poverty. Poverty is not a single reason. There are two reasons mentioned in this book. In 90s, education for
global movement, education for all, সবার জন্য শিক্ষা, সর্বশিক্ষা অভিযান, now presently সমগ্র শিক্ষা অভিযান. A global movement began was in the year 90s, 1990s, Jomtin Thailand Convention, then Dhaka, re-evaluation of the Jomtin Declaration. Then now under the so many international convention and the national scenario, now government of India just proceeded to make education as a fundamental right, making education as a justiciable right for Indian children. All of you know, there are so many articles under the title of directive principles of our constitution. Article 45 tells states shall endeavor to provide within a period of 10 years of the commencement of the constitution for free and compulsory education for our children until they complete the age of 14 years. But decade after decade, no central government paid no attention to this very article. But government has taken so many schemes and programs, but didn't comply the constitutional obligation. State fails. Why? Well, how the state tends to obey? There are escape. There is an escape route through which government of India escaped. If you have a glance at the slide, decade after decade, our constitution, then the report of the Indian Commission report, every committee and commission, just they recommended to extend our goal. 60s, then 65, then 70, 85. But no commission recommended to amend our constitution. Article 45. Article 45, actually directive principle, not a justiciable rights. If any Indian government or any state government, it doesn't fail to maintain, nobody can take legal action against the state. Not justiciable rights. That's why another article within the limits of its economic capacity. This is the escape route. All of you know Unni Krishnan judgment and Karnataka and others judgment in the year 92-93. This judgment actually right to education already embedded within our constitution, but it was misplaced. Actually, it should have been placed within the fundamental rights. Unfortunately, it was placed within the directive principles. Article 21, right to life, right to liberty. How your life would be meaningful without education? How you can enjoy your life without education? Then the judgment tells the right to education must be constitutional right, fundamental right. It should be changed, transferred from the 45 to 21. Then the amendment created another new article 21A in the year 2002. But when the judgment came, actually judgments saying education for the children till 14 years. They didn't mention 6 to 14. Actually, the judgment was about 0 to 40. But when our Indian government in the parliament made an act based upon the amendment, they framed up Right to Education Act 6 to 14. Actually, 0 to 6 has been left out under the directive principle, not justiciable right. Government always take escape route. How to deny the rights of our children? The Supreme Court verdict has not been implemented till today. Latest NEP 2020 after 20 years last National Education Policy 1992. No doubt it's a potential national policies, but there are so many uh, sections or promise or provision or announcement, pronouncement or policy proposition are very weak in terms of ensuring our child rights. Please look at the slide. New education structure, NEP, 5 plus 3 plus 4. 5 means foundational stage, 2 years, foundational stage, 3 years. First 3 years, actually pre-primary, preschool starts at the age of 3 of our child. The first 3 years without constitutional right. Then next 2 years under constitutional right, justiciable rights. How can you align when the teachers and head teachers and the administrators organize any educational programs? So how can you manage 3 years without constitutional rights, another 2 years under constitutional rights? This is a weak proposition. Then policy calls for removing hard separations between academic vocational stream, no doubt good. Accordingly, proposes a beginning with vocational exposure at early stages, early ages, in the middle and secondary school. Middle and secondary school means class 6. Middle stage begins at grade 6. The NEP 20 proposes to start vocational education at an early stage, grade 6. What will happen? Students can be introduced to vocational subjects from as early as grade 6. This thus will ignore the implication of ensuring fundamental mainstream education for all students. Actually, when the student coming from backward community, disadvantaged section, admitted in vocational education, he or she will be denied fundamental schooling, constitutional schooling system. He or she will be diverted to another education system. Linguistic polarity, another due to time constraint, I conclude so many scenario regarding the denial of child rights. Actually, at the end, I want to say elementary education, grade 1 to 8, constitutional rights is our public good. Public good means not pure good. Public sector also is in the elementary education. That's why not purely public good, but public good. Public good means children will not face any competition regarding access, regarding retention, and completion of their education till class 8. No rivalry. But we have to ensure then our policy NEP 2020 will be pragmatic. Otherwise, the policy proposition will remain in papers. We're talking about everything in our seminar, but our political will must ensure our rights of our children, all the provisions, all the rights embedded in our constitution and the international convention must be implemented by our nation, state India. Thank you for your kind patience. Thank you, ma'am.
Thank you, Dr. Mundul. We are delighted with the rights of children or child's right from the time of birth. Even children 0 to the age of 3 must have rights, and those rights must be recognized. I have only one question. You need not answer that if vocational training starts at the age of 6 or 8 or something like that, which is actually happening in the artisans' families, the weavers or painters or those who make idols, poor. So, or those who make pot, etc. in the potter's house. So the whole family works, even children work. Little work, but they do. So will they have, there will be another debate again whether child labor is entering into practice. So if that vocational training is for production as for civil as it is. So that their portion is to be taken. Anyway, you need not answer right now. No. Go on. The portion is to be taken. I think they will say that only. That in that tradition, it is also mentioned in NEP, right? Am I right? Yeah. So I'm not against the NEP, but I was mentioning those who will be implementing any NEP, they should take care. Thank you very much. To Shruti, Smriti, and Balav, and the current times. That's it. I that place was saying something. Exactly the one put the water. Now, Adimangalacharanam, Vande Vani Vinayaku, Namo Namo Namo, Guyo Guyo Namansi, Pandita Pravaraya, Pandita Varishtaya, Vidya Sagaraya, Jnana Sagaraya, Daya Sagaraya, Shri Shri Ishwar Chandra Mahadevaya. Now, I thank the organizers of the seminar, and I've already said the 3 departments, and those are Dr. Piyali Vishwas, Dr. Rakti Dev, and naturally the IT section who is heading that, and above all, Professor Shruta Padaya, principal of this college. I congratulate the organizers for taking up such a novel topic for discussion and deliberations and its ramifications. I just was scribbling some days back on such subjects of Dharma Shastra and how those have been utilized for justification in the branch of philosophy, Indian philosophy, because it's, I find, justification because it is the Indian knowledge system. So how the Dharma Shastra, the rule of law and justice and litigation, as we have found, this crept into the area of Indian philosophy and how it influenced and also literature. Now, I say about inheritance we are learning and about Stri Dhana, and there is debate also whether the Stri Dhana is absolutely in independent control of the Stri, of the woman, or she has to take permission from her guardians as male.
as mentioned, father or husband or son for utilizing that for any purpose as desired by herself. So a woman, this was in debate. So, and again, in Mahabharata, Vyasika Mahabharata, in the advices of Vidura, I was reading a verse a few days back, which says, children, children's right was being answered and discussed. And women and bonded labor persons do not have any right on their personal earning or property. And then the line is very difficult to accept. Tani tasaiva jasya te. Tani dhanani tasya eva. Those riches belong to him. Tasya eva. Only him. Jasya te. All these persons, women and the children and so on. This one. Another thing is about witness, what's being said. Now, Manusmriti says, I hope from some Hindu debate that some women, distracted women or something like that, and much of women is not said in the witness section, but people engaged in the area of music, dance, and entertainment, like presenting drama on stage and so on. So, in today's parlance, we can say entertainment industry. So those people are derived from giving witness, appearing as witness in court in case of any litigation. And details is there. And why? The reason is very difficult to accept because they earn money in their profession and they will be greedy and they can be influenced by offering money to them. As if any other person does not earn money and may not be greedy to get more money to give false witness. Now, more difficult than that, I am actually, when not in my mind, I raise the question to this point that if there is any litigation regarding any personal matter, like Parishya or Danda Parishya, or in matters of the Samhoya Samutthana, 2-3 groups may agree, or groups of people may agree that we perform this on stage, this drama or that, or series of presentation as it happens all over the country ever since. In villages or elsewhere, 2-3 groups join, a farmers group join, and then they earn also a little bit. So, if there is any litigation in kind of these things, including Samhuya Samutthana, who will be the witnesses? Can those authors of the Shastra or can this person conducting the Dharmadhikarana exclude these persons who are involved in the litigation itself from giving witness? So this debate is not raised, not even by commentators. Anyways, I come to another point. It is said several times that all are equal. And Baladapi Grahitavyam, Yukta Mukta Manishivi. And even Loka, no jati, no janmo, no nothing matters if some wise sayings are available with the person. Like Vidura in Mahabharata, he is Dharma Varishta, is the best among the knowledgeable persons. He is the most wise person. He has the highest wisdom and knowledge. And Vidura is praised everywhere as Dharmishta, as Prakta, as Prakotama, as Praktavarishta, and so on and so forth. But who was Vidura? He says, Shudroha, because he is born of the Shudra mother, Vidula. But he is the embodiment of Dharma. And that is in that Vayasika Mahabharata itself. And that Vidura
great Viguro also says in his Prajapat Parva, saying that women and young people should not be involved in mantrana, in counseling regarding the administration, royal administration. So these are the things which we have to adjust now. And what ramifications can these sayings have? I'm not asking people to be averse to Bhikkhula's wise sayings, but we have to weigh them and compare them with the previous sayings about the qualities of ministers of different grades and what are the qualities and that so that there is no mantra bheda, no divergence. So fickle-minded people should not be there. Those who are too busy with their personal things should not be there. Those who do not have enough educational training should not be there, and so on and so forth. And then shortly, quickly he says, so these children of young age and they're fickle-minded, and so when women get clothed, they're only one verse. But so if we get such verses, we have to wait for the ramifications and the expected dangers. I start with the Ramayana, the story of Maryada Purushottama, Avatara Varishta, Sri Ramachandra, and the Uttarakhanda, the story of Shambhuka. I long years back I wrote an article on it. And this Shambhuka was a Shudra, and he was practicing a long story, I make it short, practicing a very difficult penance. Kachinam Tapa, Sukachinam Tapa. How he was hanging himself upside down, he tied his feet with a branch of a tree and had put his head down, and he had long hairs, curly hairs, and below his head there was fire. He was not having any food or drink and so on. This Katinam Tapa started to smoke. And then, during that period, in Ramarajatva, one Brahmin, very pious Brahmin, of course, he lost his son. And the son died an untimely death. So everybody came because in Rama's kingdom, no untimely death, no early death, and this, nothing. So nothing difficult or sad or this untimely death, or Kalamritti particularly, which was the most dreadful thing in those days, should not happen. Okay. Now, what could be the reason in Ramarajata that this could not happen? Then all Brahmins and educated persons, they came and calculated, and they said, oh, that's the Shambhuka practicing this difficult penance for which he is not entitled. Ayogya. So this must be the reason that this Brahmin loses his son. And they go to Shambhuka, and Rama says, I know you are a true person, you never die, and this, still you stop this. And Shambhuka said, no, he's short. Shambhuka said, no, I won't. And then Rama beheaded him. Now, my question is, if I come to ramification within the structure of the story. Now, why did Dasharatha die? There was a curse. Okay. But that was also untimely death. Was it not? And then what does the philosophy say? Avashyameva bhoktavyam kritam karma shubha shubham. This is the result of the karma, the work done, the deed, good or bad. And oneself has to enjoy, get, suffer the fruits, the results of that deed, good or bad. And not only in this life, the work done, but also in previous life. Purvasment Germany, Jadupita, Tasya Palam, Bhoktavyam. So who could at that point of time determine, or I should say, nobody determined the work done, the karmas of the boy who died, that untimely death, or the father of the boy who was experiencing the great sad and sorrow and grief of losing
this young child. And who knows what bad action that child had in his previous births, for which he is paying the penalty now. So these philosophical questions are not raised over there. But as a student of philosophy, I can of course come to this as part of my discussion. I then should go to another point only and stop there. Now, whether the Shudra has any right to Vedanta studies, to the Brahma Sutras. And before that, I can say, see, the Vedas were not accessible to anybody other than the initiated Brahmins, Dvija, and Upanita Dvija, not the Dvija Bandhus who are born in the family of the Brahmins but who do not follow the rules and regulations and the acharas, rituals of the Brahmins. So, these three Shudra Dvija Bandhu, they were not allowed in the arena of the Vedic studies or Vedic rituals, or performing Vedic rituals. Now, okay, and for them, considering them, the Itihasa Puranas were composed. Itihasa Puranabhyam Vedatham Sampabrimhari Viventyam Prashuta Vedo Mamayam Pratarishyati or Praharishyati. So, this Vedic education and the culture should be spread among the common people, these three Shudra Dijavandhus, for enlightening them about the teaching and philosophy and everything of the Vedas. Why? Otherwise, they will be obstructing the performance of the Vedic rites, the reading of the Vedas, and all this. So they will damage it. Damage it means not physical damage only, but they will misinterpret it. So for them, the Mahabharata, the Ramayana, all these Puranas, they are created. And later on, what happened? The basic sense. Itihasa Purana Abhyam Vedatham Upabrimhaye or Vedam Sam Upabrimhaye, particularly extended among the common people. And Shavai Chaturobainan. And all these people have the right to listen to the recitation of the Ramayanas and the Mahabharatas. But, so this was education. How could then so many centuries, these common people, the Shudras and all others, have to remain so-called uneducated? Although they were not uneducated, they were unlettered. But still, these things were taken up by the colonial powers. So this was the extreme negative ramification that they were excluded from the educational arena, which was debated by Bishop Vindashankar, Swami Vivekananda, and even Max Muller, Friedrich Max Muller. They were in favor of spreading education. So, and the Mahabharata, Ramayana, and the Puranas did not exclude from these common people, the three Shudra Dijavandhus, from listening to these texts. But what happened? Later on, I find so many people come to me and say, could I read Gita? Could I read Gita? What will happen? I say, this will happen, that you read the Gita. And what is Gita? Bhagavad Gita is a part of the Mahabharata. So they are afraid, they're anxious of gaining some sin by reciting the Bhagavad Gita. How does it come? It comes from this negative ramifications, and in the ramification everything comes. How it crept into the area of philosophy. Now, whether the Shudra has the right to get initiated in Vedanta. It is said no, Shudra is not allowed to get initiated in Vedanta studies, to have any lesson on the Brahma Sutras.
Why? Because he is just the cremation ground. Is so impure, like the cremation ground. But few hover এসব এটা শ্মশান হুম? And even if by mistake, but few hover এটা শ্মশানম শ্মশানম যৎ শূদ্র তস্মাৎ শূদ্র সমীপে ন অধ্যেতব্য. And this is in the Apashuddradhikarana of Brahma Sutras. And Shankaracharya in his Bhashya, his commentary says, if a Shudra by chance is near about the place where Vedas are being recited or studied, then he should be punished. How should he be punished? Shudra Samipe Nabdhitabha. Where Shudra is nearby, Vedic studies should not be conducted. And if by any chance, because he was nearby, Atho Asya Vedam Upashrinata, by chance he was there, because others did not find a Shudra nearby and they were reading out the Vedas, then the ears of the Shudra should be filled up with boiling lead. ফুটন্ত শীষে দিয়ে তার and lamp. গালা আর শীষে ফুটন্ত গড়ন্ত অবস্থায় শ্রোত্র পরিপূর্ণম should be done. Paঠ্যমানং vedam samipe pramadadevo. If by mistake he has listened to this Vedic recitation without understanding anything, but still he was there where Vedas were being recited. Shudrasya Sisa Lakshapyam Sangtaptabhyam, very hot, that is boiling. Ati Drutabhyam, absolutely liquid form. Shrotra Dvayam, Shrotra Dvayam Paripuranam Karcham. It is in further commentary on the Shankar Bhashya, Kalpataru Pariman. And Shankara, in that section, in his Bhashya, does not give any philosophical argument. What he gave in the beginning of the Brahma Sutra, in the first sutra, who is entitled to have any entry, who is the Adhikara to come into this Brahma Sutra, who has learned the Vedas, has learned the Vedantas, and these Adhikaras are there, and who has Vashama and Dhammo and Uparati and Titiksha and Moksha. He who is aspiring liberation. Only that person is entitled. If the Shudra, you say, no, Shudra, I don't have the Shudra, because he has not studied the Vedas, he doesn't have any moksha, he's not desiring for liberation, he's busy in working and earning, but he never says. He quotes money. Shankaracharya in that section widely quotes money and does not give his own philosophical argument. Shankara is not inconsistent in his proposition of excluding somebody from listening to Brahmavidya who has not studied the Vedas as a prerequisite for listening to Brahmavidya. Since in the Bhashyam, the very first sutra of Brahma Sutra, he has explained the Swadhyaya. Swadhyaya, so for Purvamimamsa and Uttaramimamsa, of regular learning of the Vedas is an essential prerequisite. Swadhyaya anantaram eva Vedanta dharnam kartavyam. But he does not put forward this, and he says the Sudras ears should be filled up with luck and this thing. Mono's view against artisans, I already mentioned, artisans and artists of social entertainment and cultural performances are quite disappointing.
I have said it, I don't repeat again. And for that, about this Brahma Sutra, I say there is one story in the Brahmanas about one Janashruti and Raiko. Madam is present, I'm afraid. Rishi Raiko addresses Janashruti as Shudra and requests Janashruti for imparting Brahmavitta. She says Shudra, he calls him Shudra. Then how could he take Brahmavitta from him? The fallacy lies in the fact that Janashruti, who received the highest knowledge from the great sage Raiko, was addressed by the letter. I mean, Raiko addressed Janashruti as Shudra. I mean, Raiko was the Shudra, and Janashruti got the highest knowledge Brahmavidya from him, and cannot be. Yeah, so direct utterance that you are Shudra, please give me. As Vidura is always saying that I am Shudra. How could we then say that Shudras would be denied of their right to knowledge, to self, about self, the Brahman, in analogy to the denial of their right to perform sacrifice? The right to sacrifice is clearly denied, but not the right to knowledge. So, this is difficult. And Vidura's acquiring knowledge is also not answered in the portion of the commentary where it is raised. I mean, this Apashudra he called. Now, in that case, Monu and others say in this about the story of Raiko and Janashruti that no, that is only about Laukika Jnana, not about the Brahmavitta. It is said, Kulluka Bhatta explains these words, Jnana, Param Dharmam, in the Mahabharata. Param Dharmam Moksho Payam. This is in the Shanti Parvani. The better words, I think 323 chapter or something like that, one words. Param Dharmam Moksho Payam. Atma Dhyanam Adadita. Author. Author of Jnanam. Eva Upakramya. Moksha Dharme Praptya. Jnanam Kshatriyat বা বৈশ্যাত বা শূদ্রাত বা নিচাত অভিক্ষণম. Listen to Mahabharata. And Kulluka says, and Kulluka also records that the commentator Medhatiti holds a different opinion. Kulluka says, Medhatiti interprets this Param Dharmam Moksha Dharmam as commonplace and worldly act of knowledge only. Laukika Dharma, where Dharma means Vyavastha, order of act, and not Brahmavitta, not Brahmajnana. Finally, I'm saying, Jayanta Bhatta in his Nyaya Manjari, so you see the ramifications. One text says that Shudrova, Vaishyava, Kshatriyava, from him the knowledge, Param Dharmam, Mokshopayam, Vijanihi. But the interpreters, the commentators come and say, no, that is not the highest knowledge. That is only the Jnana, the good knowledge, the Satya. And about the Artatya, whose word, the knowledgeable person, the wise person, whose words after the Vedas, after the Vedic words, whose words would be accepted in any matter of debate, dispute, and even litigation as valid as verbal testimony, Shabda Praman. So Aptavakya is Shabda Praman because the Apta does not have any need, this cholo or deceiving somebody or telling lie and so on. So
What are the disqualifications of normal speakers whose words cannot be taken as verbal testimony, as evidence? In case of dispute, of the after only these words can be taken. Why? Because the after will not have those difficulties and those defects. Why? Not only because he is honest and so on, but because he does not need to tell lies, etc., etc. So Jayanta Bhatta in his Nyayamanjari says the quality of an after, the quality of an after is who is trustworthy, that is a trustworthy, wise person whose words can be accepted as evidence, as verbal testimony, may equally exist. The quality of an after, those qualities may equally exist in a sage, rishi, and educated, civilized, cultured person, Arya, and even in any outcast or foreigner. After Twang Rishyartam Lecha Samanam. But the commentators come and say, so this is the context, in context of that verbal testimony. Now, but then the commentators come and say, no, 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 here it does not mean that Lecha, Rishi Arya is okay, Rishi Vachanam, but with Lecha, that outcast and ordinary people or Shudra, it is not that. Now, what is the Lecha? Bodhayana says, Go Mansa Khadako Yastu. Who eats beef? No, I may be put into jail for uttering these sentences now. Yastu Biruddham Bohu Bhashati. And the person who talks always too much against all order. Viruddham Bohu Bhashati. Sarvacharo Vihinascha. Who is not following any of the rules and regulations of ritual and social practice. Mlecha iti avidhiyapi. He is to be named as Mlecha. So Rishyarja Mlecha Samanam. And in the Mimamsa Sutra it is said, for understanding meanings of certain words, which of the meanings of which you have forgotten, you may go to the lectures. Now, so the interpreters, so this is the rule, this is the origin, and then how it takes different ways and interpretations as ramifications. Finally, I say, in the world of philosophy, in the IKS of Indian philosophy, two terms are very important. Those are astika and nastika. Astika normal parlance or vernacular means those persons who believe in the existence of God, who are sincere to the rituals, etc. So he is astika. And the persons who deny the existence of gods, etc., they are nastikas. Now, in the context of Indian philosophy, it is not that. In this context, it is those philosophical branches, those philosophical schools, which accept the Vedic words as ultimate, final, undebatable, unchallengeable evidence, verbal evidence. Those branches of learning are asticals. And those who deny the words of the Vedas or neglect the words of the Vedas, those are the Nastikas. So this historical change in the evidence, so Panini gives the derivation. Otherwise, those who do not believe in the world beyond, those who do not believe in the life after birth or the theory of rebirth, etc., those are the Nasticals. And those who believe Asti, then those are the Asticals. This is grammar. Panini Vyakarana. Panini is grammar. But Manu says, Yoga. Why is this betraying me every time? Just bear with me and lost. Yoga Manieta. They
Mule, Hetu Shastra Shvaya Vijo. Even if a Brahmin takes up the part of argument, Hetu Shastra, saw Sadhubir Bhaishkarya, he should be thrown out, expelled from the gathering of the sadhus, the honest persons. And how is that person mentioned? Nastiko, Vedanindapa. So here, Nastika is not defined as Vedanindapa. The person who is Nastika, who doesn't believe in those, and who just denigrates the Vedas, who abuses the Vedas. That person who is a Nastika and a Vedanindapa should be thrown out of any religious gathering, of any honest people's gathering. But later on, it became Vedanindapa Nastika. Who is a Nastika? As if the Vedanindapa is a Nastika. So that is why, even though the Jaina philosophy and all other Agama philosophy like Pancharatra, Shulva, etc., etc., they don't believe in God, existence of God, and rebirth, the doctrine of rebirth, and doctrine of world beyond, and so on and so forth. They are technically in Indian philosophical system, in Indian knowledge system, Nastika philosophies. And Sankhya and Purva Mimamsa, which do not accept the Ishvara as a philosophical concept. Ishvara Yuktam Tatra Nasti. Even so, they are Astika Darshanas. They are named Astika. This was a turning point. Jaina philosophy accept the existence of Sarvabha Ishvara. Still, Jaina Darshana is a Nastika Darshana. So, in that respect, in Buddhism also, the persons in Buddhist philosophy, those who do not believe in the theory of rebirth, in the theory of doctrine of karma, and in the cycle of life through rebirth, etc., and karma bhagya karma phala. Those are called Uchchedavadins. And others are called dharmikas. But in Indian philosophical system of knowledge, Buddhas, Jainas, all are Nastikas. That way, if we say the believing in this existence of rebirth and the Ayam Loko, Param Loko, and so on and so forth, those are Nastikas who does not believe, and those who believe are Astikas. Then only the Charvaka Darshana may be considered as Nastiko. But Mono say Nastiko Vedanindako. It is not that it is the subject and the predicate is Nastiko. Who is a Nastiko? It defines Vedanindako. No, it's not that. But it is understood as that. That is the extreme ramification of Manu's words in Dharma Shastra or India's knowledge system at all in the whole history of Indian philosophical systems and their divisions and interdivisions and so on. Thank you so much for your patient hearing at the end of the day. And I again thank the organizers. Thank you, Professor Basu, for your insightful lecture. Now, we are at the end of the first day of the conference. Sessions, and we are three sessions tomorrow. Validation session. So thank you very much for coming, and thank you for your patience to be here till the evening. Thank you so much. Please come, be safe, and please join us tomorrow at 10 o'clock. Morning.
Is balance. Is balance.
আপনাকে লিঙ্কটা পাঠিয়ে দিচ্ছি। হুম।
এটা না কোনটাই থাকছে তো
পুরোটাই।
পুরো করে দেখতে
হুম।